But extension of interim order with notice.
Extension of interim order, Lordship.
Number 40.
Upon notice?
So item number 30 of your Lordship's monthly combined list, praying for to fix the matter as a mentioned matter, because Lordship, the thing is the mining lease is going to be expired.
You are mentioning upon notice?
Yes, I'm praying for extension of mining.
Lordship, may I permitted to mention a matter in respect of item number 135. It is group 7 matter wrongly listed under group 1 matter.
Didi, dekhe nein.
My lord, may I permit to mention one matter, item number 263 of today's list for upgradation with notice. Urgency is the my lord, matter related to encroachment and unauthorized construction over the.
My lord,
Grateful.
upon notice to the respondent, my lord, I am mentioning one matter, my lord, extremely urgent, my lord, item number 79 of the today's list, my lord.
79?
My lord,
May be called, please wait.
my lord, kindly help me, my lord. My lord, yesterday the item, it was item number 83, my lord. Today is 79, my lord. All my fish products will be destroyed, my lord. My lord,
Wait, 79, let me see if it is
My
correct.
lord, upon notice.
my lord, let it be within, my lord.
Below 100, please do not mention.
My lord, this is remaining same, almost same position for last
Let
7
me
days.
see if I can call, let me see.
My lord, may I permit to mention inclusion, my lord, upon notice, my lord, I am mentioning, my lord. My lord, upon notice, one matter, my lord.
This matter?
Yes, my lord, the order is that got influence. At the time of dictating the order, you lost it. Now that the matter will appear. But mistaken in order that was not.
So there is no date at all. No, I think in the earlier order, it was fixed on 14th already. So then it will appear on 14th. Why are you worried?
No, not with the, in the order.
Not in the last order, but in the previous order, I am sure it was stated. That was 14 November. Do you have the order sheet? Dekhe neben taদের.
Order as there, my lord, but there is.
December এ থাকে তাহলে আর নতুন করে দেওয়ার দরকার নেই। আমার মনে হচ্ছে ওটার আগের অর্ডারে যেহেতু 14 ডিসেম্বর ডেটটা ছিল আমি ওটা করিনি। হ্যাঁ হ্যাঁ একবার আগের অর্ডারটা চেক করে দেব। I'll find.
No, my lord, upon notice to the other side, my lord, I am mentioning item number 274, my lord, for upgradation, my lord. My lord, land has been acquired of the petitioner, but no compensation paid, my lord. I have applied for land user certificate, that also not, my lord. My lord, may I permit to one urgent matter which I filed, my lord. Tomorrow is the returnable date, my lord, the listing date, my lord. The urgency is that, my lord, extension of sand mining lease, my lord. Due to the respondent authority, I have deferred to sand mining.
If tomorrow is the returnable date, it will appear tomorrow.
Urgent matter, my lord.
Huh? It will automatically appear.
Urgency
If
is
the
that.
returnable date is tomorrow, it will automatically appear tomorrow. Upon notice to the other side.
This is my motion state. It was not, it was hard.
No, I understand, but the other side had appeared in the motion.
Other side means no. State is no subnotice will state. No private respondent.
State appeared in the motion.
No. Nobody appeared.
Give the number.
Lordship, may be permitted to mention, Lordship, one matter for. Lordship, may be permitted to mention one matter for upgradation. It is item number 501 in the combined monthly list of 2023, Lordship.
Are you mentioning upon notice?
Lordship, I shall serve the notice upon.
No.
May I want to mention one upgradation, my lord. I know 300.
Upon notice to the
Upon
other
notice,
side.
my lord. 312, my lord. My lord.
Item number?
312, my lord. As per your lordship order, my lord, demolition order has been passed by the NHI, but the demolition has been taken place. It has not been taken place, my lord.
Monthly list of 353 minor matter relating to fake stamp paper, my lord. I have served the copy.
Mentioning upon notice?
Yes, my lord.
Land of the petitioner unlawfully acquired.
Are you mentioning upon
but no-
notice to the other
Yes,
side?
yes, lordship. Yes, lordship.
Yes, call the raise list, please.
Item 1.
Yes, what is the connection?
I don't know also, my lord. My lord, I am appearing on behalf of the petitioners. My lord.
I think the date has been wrongly recorded. I'll just find it. This will be 412. It's 411. Inadvertent error has crept to the order passed on 412 like button, I think 12/2023. In the said order, 411/2023 we read as 412/2023. It's recorded as 411. It should be 412. The department is directed to incorporate necessary correction. This order will be treated as part of.
Item 2.
Well, I am for the alleged contempt number 20. There is an order from your lordship directing this matter will appear on. For
The
correction.
date needs to be corrected.
My lord,
Instead of 412, it has been stated as 411. I'll
My
just
lord.
correct the date.
my lord, my lord, my lord.
Same order.
The matter will appear on 19th. Huh?
Item 3.
I'm appearing for the respondent, my lord, in this case. For respondent, my lord, I am appearing.
I'm for the respondent number 3. That's sorry, Eastern Railway. And praying for not today, lordship. 3. I'm Eastern Railway. I'm Eastern Railway. I'm praying for not today because the affiliate service is not. No, it is for the extent of interim order, my lord. My lord, kindly come to page 90.
You are for the petition.
Petitioner. Yes, my lord. Last order, my lord, page order dated 19th September 2023.
Yes.
No coercive steps to be taken against the petitioner by the respondents in respect of the plot in question till the adjourned date. Adjourned date was 30th, my lord. So, and there was a direction to file report. No report has been filed yet, my lord. Lordship, report is let the time to file report be extended and.
Now we shall file our affidavit in opposition, my lord. Let 4 weeks time be given.
Yes,
We shall file affidavit in opposition in this case.
Affidavits are not required. A report in the form of an affidavit is called for.
Yes, my lord. The 4 weeks time, kindly. We will file it, my lord.
You are appearing for respondent numbers 1 to 3.
Yes,
Eastern Railway.
Eastern Railway, yes. Union of India, my lord.
Yes, sir.
The respondents
Volunteer
seek
appear.
extension of time to submit the report in the form of affidavit
I'm Eastern Railway. Yes.
as sought.
Yes.
Paragraph, let the matter appear under the same heading
Eastern
on
Railway. P number.
25th January.
Yes, my lord, yes.
25th January 2024. Paragraph, the interim order granted earlier is extended till 31st January 2024 or until further orders, whichever is earlier.
31st January. 31st January.
Item 4.
Well, similar, same matter.
4 and 5 same, my lord.
Same
4
order.
and 5 same, yes.
Same order.
And 5 is also 5 is same.
Item
5
5.
Same.
Same order.
Same.
Great.
Yes. Junior naam de dega.
My lord, in this matter, Mr. Soikot said that he is appearing on behalf of the petitioner. Malad, due to his personal difficulty, he has not come to court. Malad, praying for not this week, Malad.
Oh, my lord, I am for the petitioner, my lord. Yesterday, my lord, my landed junior perhaps was not in a position to address your lordship. It is a land matter, my lord. My lord, we have challenged one notification put it by the government of West Bengal that there is some embargo that I cannot sell my own property after 14T3 proceedings. That is under challenge before your lordship.
This court will not have jurisdiction
Regarding land matter, my lord.
regarding land reforms matter. This is under the Land Reforms Act. 14T3, this is under the.
No, 14T3 is not under challenge. The subsequent notification that land department which has issued that I cannot sell my property, that is a backdrop, my lord.
That is under the Land Reforms Act.
Yes, that is a land.
So this court will not have jurisdiction. It's a specified act. You are aware of the Land Reforms and Tenancy Tribunal Act.
Yes.
This court will not have jurisdiction if to approve.
Oh, I was under impression, my lord.
That's why I have kept this matter as to be mentioned.
As a lordship. As a lordship.
I'll allow you to withdraw the writ petition and approach the appropriate forum.
My lord,
Otherwise, I have to dismiss it on this.
my lord, may I pray for one indulgence, your lordship? My lord, kindly allow me to correct the presentation form and the cost title so that I can approach you with the appropriate. Because my lord, it is so urgent, my lord. If I will not get the chance before vacation, my lord, they will take away everything, my lord.
Very well, I'll allow you to correct.
Lordship.
On prayer of the petitioner, liberty is petitioners, liberty is granted to correct the cause title and the presentation form of the writ petition. Paragraph, the petitioners seek to withdraw the writ petition and
No.
take appropriate steps before the appropriate forum. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioners to approach the appropriate forum for redressal of their grievance. Paragraph, there shall however be no arrest to costs as
As a lordship. Well, I thought it is a land matter.
Land Reforms Act, this
No, no,
cannot
no,
be.
it's. Well, I'm grateful.
Necessary করে দিন প্রথমটা necessary করে Yes, next.
Item 7.
Well, at item number 7 and 8, I beg to appear on behalf of the petitioner.
Yes.
Well, in these
This is
matters,
also, I believe, under the Land Reforms Act.
well, the notice is under Estate Acquisition Act.
So that is also a specified act which cannot be dealt with by this court. And you have prayed for a writ not to act in furtherance of the notice under the Land Reforms Act.
Lordship.
So this court will not have jurisdiction, I'm sorry.
Lordship.
So I'll grant you liberty to withdraw.
Yes,
Otherwise,
liberty
I
to
have to
withdraw
dismiss on
to
this.
file a fresh.
Same on. এটা করুন, the matter, affidavit of service. Mr. Day is appearing in this matter. Item number 7, yes. I'll release the matter. I'll allow the petitioner to take steps. The matter pertains to the West Bengal Land Reforms Act, 1955. The petitioner seeks to petitioners seek to withdraw the writ petition and approach the appropriate forum for redressal of their grievance. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioners to approach the appropriate forum for redressal of their grievance. Paragraph, there shall however be no arrest to costs as in certified website.
Item 8.
Well, item 8, same.
Same matter. Same order.
I think affidavit of the.
Are you filing your affidavit of service?
Item 9.
My lord, item 9 and 10, my lord, praying for not today, my lord, the learned advocate of the petition.
For compliance?
From the.
Let it appear in January, let it be complied with.
হ্যাঁ বলুন
Affidavit of part compliance submitted on behalf of the alleged contemner is taken on record. Paragraph, learned counsel for the alleged contemner seeks accommodation to comply with the order under contempt in its entirety. Paragraph, let the matter appear under the same heading on 18th January.
Grateful.
Ten also same? 10 also same?
Then we have applied the order, my lord. And your lordship, in spite of that, your lordship was decided. Another chance.
So they wanted to use an exception. They wanted to use an exception to this.
But we have not even used. Nothing was there, my lord. The exception.
Not today?
Not today.
Not today?
হ্যাঁ দশ
Mr. Then not today. Let it be.
Yes.
Item 11.
Item 11, my lord, pursuant to your lordship's direction, my lord, the hearing has been conducted and the final decision order has been passed. The only part, my lord, the communication part has not been complied with. But kindly adjourn.
Come back with an affidavit of compliance.
Compliance, sir. And your lordship, if your lordship directs me, I can hand over a copy of the my lord information.
18 December,
18.
we can dispose it of. Learned, it is submitted on behalf of the alleged contemner that the order under contempt has been substantially complied with. Stop. Learned counsel seeks to submit affidavit of compliance on the adjourned date. Paragraph, let the matter appear under the same heading on 18 December 2023.
One thing, if you are saying my kindly record a copy of the imperial reason of I have handed over to
Copy of the
reasoned order, final reasoned order.
একটা line add করুন, copy of the reasoned order is made over to learned counsel for the applicant petitioner in court this day.
One thing from the order sheet, only one line I have.
ওটার আগে দেবেন।
There's no ROR filed. I have already filed all ROR up to date. Record of rights.
Going to merits, let him come back. I cannot go into merits
They
of
did
the.
not, they have accepted and now they say in the order sheet, no ROR was filed. But this is very unfortunate. I also,
I cannot go into merits of the order in a contempt application.
no, not merits. Lordship can consider if this on the face of the record it shows that it is wrong. So Lordship can take cognizance of that. If it is, if I do not file or they do not accept
I
it,
can take cognizance in a separate proceeding,
if,
not in a contempt.
I don't know what.
Let him come back. Let him come.
12,
I am for the applicant lordship, pursuant to your lordship direction,
Comply?
no copy has been served till today.
Order has
That
been
was
complied.
directed to previously serve the copy, thereafter matter will be heard.
Earlier day, I have submitted reason order, but he refused to accept it. That is why this is a affidavit compliance. But this is district magistrate today is present. 10. It is in affidavit. Kindly consider the
Order fully not complied, lordship.
kindly consider my copy.
I filed the exception.
You filed exception.
Yes, I want to file the exception.
Order of demolition is there. His prayer was
So, lordship,
filed on-
within
order
15
was-
days, DM was passed the order to remove the unauthorized encroachment, but till today, no encroachment has been removed.
on the part of the
This
district
is the
magistrate. there is-
scenario of the DM
Let him
as well as
complete.
the
Let
police
him
concern,
complete.
Lord.
Please have patience, sir.
ঠিক আছে, বলে দিলাম।
I filed the exception, lordship.
আচ্ছা ঠিক আছে দিবি।
Affidavit of compliance you're filing today?
Within 10 minutes I'm deposit supplying the original copy। আর একটু বলতে দে না আমাকে। it is under
Just now he is
আরে দাঁড়া রে ভাই আমাকে বলতে দিবি তো।
Why
What is
are you
this?
simultaneously
I am
It is very,
the
very
applicant.
impossible.
It is my
No,
content.
this is my technical issue. I could not affirm you.
Your contempt, it is his contempt with the court.
Yes,
Let him
Lord.
complete. Please wait.
He is in. DM is present for affirmation. It is being affirmed. I am handing over the copy of my copy. Within 10 minutes, I am.
Within 10 minutes. I give you 10
একটু
minutes.
নিয়ে নিন না,
I'll pass the
recording.
order, but please file within 10
File
minutes.
the exception, Lord. Liberty may be given.
Yes.
Let it be kept with the record.
Affidavit of compliance submitted on behalf of the alleged contemner is taken on record. এটা ওটা দিলে ফাইল অর্ডারটা টাইপ করবেন
আমি বলছি আমার কথা।
Paragraph, learned counsel for the
এই করুন
applicant
না আমার কি
petitioner
আছে?
seeks to use an exception to the affidavit. Paragraph, let the matter appear under the same heading on 8th January.
8 January. In course of the day, I'm
10 minutes. That is
10
not
minutes.
course of
Yes,
the
10
day.
minutes. That is why everything is
Order will
ready.
be printed only upon filing your affidavit.
8 January. Grateful, my lord.
Hello.
বুঝতে হয় আমি কি বলছি। কথা বলতে হয়।
13,
Yes,
Yeah.
13. I'm for the
No,
petition.
yes.
Yes. New contempt. So please serve and come back. You just serve the alleged contemner and come back.
Yes, lordship, I have served.
Yes. January. Sorry, sir.
কারণ আছে নামটা দেবেন
11 January.
আপনার নামটা দেবেন
14,
Yes.
My lord, after dismissal, we filed for
After?
after dismissal, my lord, we filed for the So what case?
You need copy.
Not today, my lord.
Very well, not today.
এই একটা নাম দিয়েছে
My lord, in this matter, my lord, I am appearing on behalf of the state respondent. My lord was directed to, my lord, measurement the area of the land. My lord, Hume Pipe petitioner allegation is, my lord.
Yeah, I am for the petitioner, my lord.
Petitioner allegation is, my lord.
Attention to the order passed by your lordship on 4th September 2023, my lord, your lordship. Kindly have a look to the order. 4th September 2023. That cannot be, my lord, complied with for the implemented, my lord, for the reason, my lord, the entire area is covered by rainwater, and that is why again your lordship was pleased to pass an order on 5th October 2023.
Yes.
Today, what I am submitting before your lordship till today, it could not be carried out, my lord. So, your lordship, kindly, my lord, it is expected that February, my lord, in the month of February, if it appears before your lordship, my lord, then purpose will be served. In the month of January last, my lord, there might be a my lord, position to measure the property in question. Your lordship, kindly have a look to. Under such situation, could not be done as yet. Let it appear in the monthly list of February, your lordship, kindly in the meantime, that could be done.
My lord, with due respect, my learned senior friend, my lord, kindly fixed in January, any date, my lord. In the meantime, we measurement and my lord, we file a report and my lord, kindly, my lord, if do not adjournment any parties, my lord, because my lord, every time, my lord, we fixed a date, but they made an adjournment.
They are not making
No, I never did it.
Not here, my lord. This is the PLR office for the measurement, my lord. My lord, kindly, my lord, kindly
As the
my lord,
BLR
record my
is not the
submission,
expert,
my lord.
as the
We
BLR is not the
measurement
expert,
and
so
my lord,
you
file a
lordship
report
directly.
without unnecessary adjournment before the BLR office, my lord. Because, my lord, we time a fixed. Again, we fixed a date, my lord. No one present this.
No. We went that you could not go there due to heavy rainfall. Why you are submitting like this?
As directed by the order passed on 4th September 2023 would not be conducted till date. Stop. Paragraph, the Block Land and Land Reforms Officer is directed to conduct the said enquiry in terms of the order dated 4th September 2023 within 15 January.
My lord.
Within 15 January 2024 without granting any unnecessary adjournment to any of the parties. Paragraph, let the matter appear under the same heading on 30th January 2024. Paragraph, the Block Land and Land Reforms Officer should comply with the earlier order of this court mandatorily by the time frame fixed.
My lord. Great.
With notice to the petitioner, my lord, with notice to the petitioner, my lord.
Yes, that's
Date,
the
date to be fixed by the BLR, my lord, may be notified upon the my lord, petitioner before your lordship.
Stated in terms of the order. The orders is
My
has-
lord, grateful to you, as your lordship, grateful to your lordship.
Next.
Deeply applied, my lord.
From item number 16 to 20, my lord, Mr. Ujjwal Rai is appearing. Lordship, I was humbly praying for a very short Passover. Mr. Rai,
Passover is not possible in this court.
so Mr. Rai is on lake over before courtroom number 15, my lord. That is why I was humbly praying, my lord. Vacation. As your lordship pleases.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on.
My lord, from the last 7 occasions, they are taking time, your lordship.
From the earlier occasion has directed that matter.
Last few
Yes,
Yes, my lord.
on the last.
My lord, I was humbly praying for a very short passover. Mr. Rai is on leg at courtroom number 15, my lord.
Aware that Passover is not possible.
My lord, on the last occasion also he has the same prayer that.
I'm sorry, my lord.
Let the matter appear under the same heading on 19th January 2024. Paragraph, it is made clear that the matter shall be disposed of shall be considered on the matter shall be taken up for consideration of on the adjourned date, even in absence of either of the parties.
Yes.
If the petitioner is not there, no Passover, no adjournment.
19th January. Huh? January. 17.
Same order.
17.
Till 20.
My lord, it is
Till 20.
till 20, my lord. Yes.
21.
Fourth September 23, your lordship was to direct the respond number 8 on the my lord suggestions made by Mr. Shishanu Bandyopadhyay that he will demarcate the plot and submit a report. It appeared, but no.
Who is appealing for the 8th respondent?
Mr. Shishanu Bandyopadhyay, ma'am.
In this matter, Mr. Orko Kumarak appearing, he's on the way, my lord. Just.
Is the inspection done?
তারও তো এফিডেভিট নেওয়া যাবে এই
কিছু আছে
তাই 13 নম্বরে
once the report was submitted.
It says that the line was to be shifted. Has that been done?
That has not been done. So, for the my lord, finalizations of the entire matter, Mr. Bandyopadhyay, my lord, has on that date, your lordship will direct the my lord, the BLLRO to demarcate there in presence of the respondent, such and such. But nothing has been done. Because notice has been received in this regard. On the last occasion, none appeared on behalf of the respondents. The lordship will direct and to comply with the order, that order. However, but the demarcation also the steps should be taken on the part of the respondent authorities in this regard. And they have admitted in their earlier report that the lands of the petitioner has been taken for laying down the pipeline in the process of widening the road. So proper steps should be taken after completion of the entire procedure. Report submit. Report. না ইনকোয়ারি রিপোর্ট দেয়নি
Yes, you're appearing for the state. There was a direction to demarcate the plot in question. Where is that done? Where is the
Lord, let the BLRO be personally present before my lords in Monday with the compliance report, my lord. And if the compliance report is not there, my lord, as officer of the court, my lord will kindly pass necessary orders against the BLRO. Might be disciplinary, might be removal from office, whichever my lord feels fit and proper. My lord, the executive engineer, on the last occasion from July, there has been communications, but perhaps it
BLR.
appears, my lord,
Communications to the BLR.
BLRO, my lord. Nothing has happened, my lord. Last communication was on 1st of December 2023, my lord. I'm handing over a copy thereof.
So let him come before this court and
No,
explain.
let him come, my lord. It is the highest constitutional court of the state. If the BLRO doesn't understand, he understands the hard way.
The court will make him understand. Let us see. It is submitted on behalf of the state respondents that despite several communications made by the executive engineer, Tomluk division, PHE department to the block land and land reforms officer, Kontai -Roman 3 block, Purbo Medinipur, no step has been taken by the latter, LATTER, for demarcation of the land in question in compliance with the order passed by this court on
My lord,
4th
perhaps
September
no
2023.
no steps will be a wrong submission, my lord. The compliance of the my lord's order has not been carried out.
Despite the despite 23 comma তারপরে বাকিটাকে দেন no step কেটে দিই despite several communications made by the executive engineer to the block land and land officer, তাই তো? No step থেকে কেটে দিই the said for compliance of the order বলেছি ওখানে কি ওখানে add করুন for compliance of the order of this court passed on 4th September 2023 comma the said order has not been complied with by the block land and land reforms officer. Paragraph. The block land and land reforms officer, being the 8th respondent herein, is directed to personally appear before this court on 12th December.
No, as per my lord.
12th December 2024 at 10:30 a.m. and
along with the compliance report.
And submit an explanation as to why the said order has not been complied with by him till date. And also as to why necessary steps shall not be taken against him for non-compliance of the court's order. Stop. In the event the order has been complied with, compliance report in the form of an affidavit be submitted by the block land and land reforms officer on the said date.
12.
Paragraph, let the matter appear under the same heading on 12th December.
Sometimes the officer tends to forget that we are officers of the court first. Enough.
22.
Your Lordship, I am for the petitioner, my lord. I am praying for not this week, my lord, for item number 22 and 23. Mr. Nilanjan Bhattacharya is appearing in this matter. He is ill, my lord.
Not this week means after vacation.
After vacation. 22 and 23.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 22nd January.
My lord, the only thing is that the interim order will be expiring on 20 the last week of December, my lord. So I was just.
The petitioner should have been present today in that case.
Yes, my lord. But my lord, he is.
Cannot carry on with the writ petition only by extension of interim order, sir.
My lord, I am just saying that kindly keeps it on Monday, my lord.
Not possible. File देखिए 22 20 December.
Extension हुए तो 4-9 को दिन.
It is till 20th December. Let it be extended till 31st January. The interim order granted earlier is extended till 31st January 2024 or until further orders, whichever is earlier. 22 then.
22 January, no? 24.
দাদা আছেন? 24 Milord, Mr. Robin Dotto Milord earlier occasion was engaged. And Milord now,
He is appearing.
10th Milord.
Mr. Dey is appearing. I've recorded Mr. Dey's appointment.
This is the case. Milord, where Milord the land was Milord acquisition in the
A
year.
similar issue is pending before an honorable division bench.
Honorable division bench that was pending. I think that has been Milord.
That is still pending.
ফেয়ার কম্পেনসেশন একটা কি দেবে যেটা বেনিফিশিয়াল অ্যাকোয়ার হ্যাঁ তারপরে রাস্তা হয়েছে সব ব্রিজ হয়ে
পারচেজ করে দাও
সেটাই
Similar issue is pending before the division bench.
no that has been probably Milord that is been decided
Similar.
It is recorded, so I have to adjourn the matter.
Yes, madam. Then
Monthly list of
Mr.
January.
Dotto submitted that Milord on the basis of that Milord
my lord, your lordship, you have a copy দিও আমি করে দেখে নেব my lord after vacation your lordship fix the matter I must you আমাকে একটা কপি দিয়ে দিও পরে দিও এখন দিতে হবে
Let it appear in the monthly list of January because this matter has to be disposed of by the division bench. Since it is
Milord,
recorded,
I think Milord it has been disposed of. Milord, I will talk to Mr. Dotto. Lordship kindly take it up in this month.
if it is disposed of, please show me the judgment.
Milord, I will bring that. Lordship
মেনশন করতে পারবে মেনশন করে মেনশন নিয়ে চলে আসবে
একটু বলে নি মানে before Lordship kindly take it up before vacation if
Before vacation, it will not be possible. Come back in January, I'll fix a date. In view of the observation,
Milord, I am serving copy Milord here and now.
please do that. In view of the observation made in the order passed on October 6, 2023, let the matter appear under the same heading on 19th January.
19th.
January.
Sorry. 25.
But I appear for the petitioner, my lord. On the last occasion, there was a direction upon the state to file a report, my lord. Since they have sought for filing a report in this matter, my lord. Here, my lord, the land of the petition was acquired by the National Highways Authorities, my lord. Thereafter, my lord, arbitration proceedings was. I came to learn that the arbitration proceedings was made, but no notice was served, and behind my back, the award was passed, my lord. But the last occasion, the land advocate of the state submitted they wish to file a report, my lord. But
How arbitration proceedings before the award was declared?
no note.
Arbitration proceeding.
But I came to learn that the arbitration proceedings was there, my lord, but no notice of under section, my lord, the national under section 3C2 of the National Highways Act was served upon the petitioner, my lord, and my lord, the arbitration only, my lord, the award was, my lord, no award of the was communicated to the petitioner also, my lord. But that behind my back, but the arbitration proceedings was held, my lord. But the last occasion, my lord, the land advocate of the state submitted to file, they wish to file a report, my lord. But may I get copy of the report, my lord, if there is something?
You served a copy?
Just a moment.
You want to go through this and come back?
Just my lord, one. কি লিখেছে?
You serve advance copies. We miss a day, isn't it? Report in the affidavit submitted on behalf of the state respondents is taken on record. Paragraph copy of the report is made over to learned counsel for the petitioner in court this day. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph let the matter appear on the same heading on 18th January.
18.
একটা জায়গায় ডিফার করে যাচ্ছে আপনাদের অনেকে ডিফার করে যাচ্ছে একটা জায়গায়
26.
Get
26 to 30. Mr. Palms, I think was after vacation.
For Union of India. Appearing for Union of India.
National after vacation. On prayer of the petitioner, the matter is adjourned. Paragraph let the matter appear under the same heading on 19th January. 26 to
26, 27, 28. 28. Oh, 30.
26 to 30. Who is appearing in the other respondents?
My lord,
You are
item
appearing
number
on-
26, 27 and 28, my lord, I am appearing on behalf of the National Highways Authority.
I'm happy for the Union of India.
I suppose
29 tag, but
29 and 28.
29.
Give your name, it's being adjourned.
494.
29, 30 minutes.
Yes, 31. 31, adjourned.
लिखे दो
31.
0.
31.
তুই লিখে দাও না বালের অর্ডার দিল সে দেখবো বললে
29, 30 তো আমাদের ইস্যু।
হ্যাঁ লিখে দাও
Yes, a report was called for 31, Mr. Gonzalez. 31 petitioner. 31 petitioner. No one.
লিখে
31. State was to file a report. Several extensions have been granted.
Last occasion, my lord was pleased to direct to, because pursuant to the prayer made by the state, my lord. Last occasion.
Mr. Bandyopadhyay has no report.
My lord, today we have missed the brief.
After vacation, Mr. Roy,
As well, Lord, please, in absence of the report, my lord,
that cannot be dealt with.
the state to take some initiative to file the report.
না আমার কোনো সে না হলে সে নিয়ে আসেনি ব্রিফও নেই
Learned counsel for the state respondent seeks further extension of time to submit the report in the form of affidavits as sought.
ভালো
Paragraph as a last chance, the prayer is allowed. Mr. Bandyopadhyay, last chance, several extensions have been granted. Paragraph, let the matter appear under the same heading on 15th January.
ভালো
32. 32. Item 32.
Lord, I'm appearing for HITCO, my lord.
And for the statement.
Petition,
My lord, I am appearing for the Metro Railway.
petition is not there.
My lord, actually, my lord, this matter has become infructuous. My lord, they have filed a supplementary affidavit, my lord, which is beyond the scope of the writ petition. Their grievances have been sorted out, lordship. But in spite of that, they are enlarging the scope of the writ petition.
Last chance has already been granted.
My lord, it was my fault, my lord, I couldn't appear on the last occasion.
Dismissed for default.
Lordship.
Several occasions petitioner is not appeared.
Every day, my lord,
None appears for the petitioner, no accommodation is sought. Therefore, it appears from the conduct of the petitioner. Dismissed for default. That is the difficulty.
my lord, they will again come and take out an restoration application.
Can't help, the law grants the liberty.
33.
Lordship, item 33, I beg to appear under the petitioner. As per the instructions, talks of settlements are going on between the parties. That's why I am praying for,
Talk of settlement is going on. That was your instruction on the earlier occasion also.
yes, actually, it is taking a bit of time. Actually, it is taking a bit of time. That's why I am praying if it can be kept in the monthly list of
Out of
February.
Mention upon settlement being arrived at.
Grateful, Lordship.
In view of the fact that a talk of settlement is going on between the parties as submitted by learned counsel for the petitioner, let the matter go out of list.
ফোন করে ডাক
34.
From the petitioner. Lord, the report was called for, my lord. Report has been filed and I also filed the rejoinder. The report. Mr. Bandyopadhyay, my lord, was appearing for the other side. In many occasions, my lord, didn't appear. On the last occasion also. Yes, yes. On the last occasion also, your lordship have recorded.
What is the matter about? Let us hear the matter. 33 you allowed on this?
So it's a matter, my lord, in which I have a lot of small plot of land. My lord, that plot of land, my lord, has been shown to have been recorded in Khotiar number 1. Now, my lord, my other co-sharers, my lord, have also the plot of land, my lord, in the same dag. But that properties, my lord, are not in the Khotiar number 1. But in respect of some portion, 8 decimal and 6 decimal, they are saying that the property is under Khotiar number 1. Now, my lord, I filed a writ petition, my lord, stating that this is not under Khotiar number 1, this is ancestral property, and all the deeds and LR record of rights, all these things in the name of our predecessors, and there is no other documents. They filed, my lord, a report stating that this is under Khotiar number 1, but, my lord, they did not show any reason or not a piece of document, nothing else, my lord, have been mentioned in the report. My lord, I filed a rejoinder stating, my lord, that
Applied for correction of records.
yes, I've also applied before the authority, my lord, your lordship kindly comes to the
Pending.
yes, that's pending. That's, my lord, at page 65.
What is your prayer?
My lord, my prayer is that only. It's, let my name be corrected. As this is not a government land, this is a private property. Let my name be incorporated. As they failed to show any documents.
You are asking for correction of records?
Yes, yes.
This court doesn't have jurisdiction.
No, not exactly that. My case, my lord, what I have been made out that this is not a government land. This is a private land.
Asking for correction, that is your prayer.
Yes, this is, my lord, exactly. I want to know whether you have you have acquired my land or not. My lord, they failed to show any reason, any case number, any acquisition proceeding number, nothing else, my lord, has been given. I only want to know that if you show me that anything else.
Can this court declare a land to be acquired or not acquired?
No, not, my lord, concerning my prayer in this writ petition, not for exactly correction of record of rights. My writ petition, my lord, is for whether this is a private land, you cannot.
Where is your representation?
My lord, my representation, 2 representation are there. One is at 65 and another is, my lord, your lordship, at 62. Page 62, my lord, another representation.
65 is for correction of record of
Yes, and 62, your lordship kindly says.
This is also for correction of record.
My lord,
And you have asked for disposal of the representations. I am sorry, you have to approach the appropriate forum. This court doesn't have jurisdiction. This is under the Land Reforms Act.
yes, but only thing, my lord, only thing, if they disclose that this is under this case number is recorded, then I could have taken steps.
It is a specified act. This court cannot deal with this matter at all. I have to dismiss it on this ground. Or I can grant you liberty to withdraw and approach the appropriate forum. Your choice.
Lord, your lordship kindly. Lord, your lordship kindly grant me some days. I'll take instruction and come back.
No instruction is necessary. in this
No,
matter.
for withdrawing and to file and granting liberty to file affairs.
Not today.
Yes.
Didi? Not today.
To appear on behalf of the petitioner, my lord, kindly remember it is that matter. My purchased land was acquired by the state. Now, subsequently, by way of different communication, the collector submitted communicated me that your land is not required. Although, as per my lord, that
SP is the correct authority. Now, on the last occasion, your lordships was come to a conclusion that I dispose of the petition to send a comprehensive representation to that effect. My lord,
No, my lord,
last
that-
day,
My lord, that was my lord, if your lordship come page 51.
my lord, may I say, my lord, on the last day, few police officials came to the petitioner, and my lord, by way of bearing a memo, my lord, they take my signature in certain documents. My lord, as a aged lady, my lord, I don't know, my lord, where I put my signature. My lord, this is the communication, my lord. This is the communication which the petitioner sent to me, the advocate on record. I think 51.
51 is the earlier writ petition which was.
My lord, earlier writ petition order.
Before that, another writ petition was disposed
Yes,
of,
yes,
my
yes.
lord.
Series
That
of
is
writ petition.
1, 2, 3,
And
4th
this is the
paragraph, my lord.
My lord, may I
That
say?
is res judicata, on the ground of res judicata, that was
My lord, may I? My lord, may I?
51 and 52.
My lord,
And now, my lord, SP, that is the SP, my lord, give a report. Instruction, এটা দেন না একটু দাদা।
আমাকে একটা রিপোর্ট দেবেন?
হ্যাঁ দেবো, আরে বাবা, না দিই লর্ড।
এইটাই কি কালকে সই করিয়েছে? এইটাই
হ্যাঁ, এটাই সই করাতে পারে। Instruction দিয়েছে। The instruction, my lord, it is not possible to return back the land, my lord.
But my lord, the SDP, but my lord,
How
my lord, I am told that the SDPO informed me that your land is not required. Your land is not required.
Where is that document?
My lord, my lord, verbally he stated.
Does that
My
carry
lord, no, does not carry. But all I want, my lord, if your lordships, my lord, kindly, my lord, pass an order to, give me one more chance to make an representation before the authority. My lord, that
How
will
is your
suffice.
petition maintainable?
My lord, I don't need to, my lord, make any
How
representation.
is your writ petition maintainable?
My lord, kindly see, my lord, 52, my lord, counsel for the petitioner. My lord, kindly see, my lord.
My lord,
Second
first, my lord,
paragraph
your
on
lordship
the-
will see 51, last paragraph. Then, my lord, your lordship go.
My lord, 52, my lord, kindly say, however, it is up to the authority to decide whether they will favor the petitioner with the desired release of the piece of land. Now, despite dismissal of this writ petition, my lord, of that writ petition, my lord Justice Vishwas, my lord, already, my lord, view all this.
Clearly held that the petitioner has no statutory right to seek release of the property that stood vested in the government. Page 52,
But
last
my,
paragraph.
my lord, my case is otherwise. It's true that that was vested. But since the collector report was that your land is not required, there lies my case, my lord.
Report?
My lord, come to page number 28.
You have challenged the acquisition as arbitrary.
Previously challenged, my lord, that was dismissed.
That
Another,
is-
that
My lord,
Second time
28,
this-
kindly see, my lord. This is their document. This is not my document. After, my lord, in
It's your prayer for release. Your prayer is challenging the acquisition.
my lord, challenging the acquisition proceeding, but not initially. But my lord, after, my lord,
You have prayed for release on the ground of arbitrary acquisition.
my lord, since the report was come from the office of the collector that accordingly the release of the said amount of any may not hamper the project. So I made my prayer in this writ petition on the basis of that report that yes, collector give me a report and on the
Report is at page.
28, P, annexer P7. Now, based on this, your lordship's last view is, okay, I will give you liberty to make a comprehensive representation. My lord,
This
all I pray.
it was issued in 1992.
Two.
And the earlier writ petition was disposed of in 2006. So it's prior to the earlier writ petition.
Yes, my lord.
Cannot be considered, sir. I'm sorry. Barred by res judicata. The same issue has been decided.
My lord, if your lordship's, my lord,
I can
kindly
grant
give
you
me.
liberty to withdraw. I have to dismiss on this ground itself.
My lord, may I take instruction, my lord, regarding this withdrawal part? Because
Let me dismiss it. No instruction is necessary.
But
for
there is
dismissal.
a res judicata is there, my lord. So, my lord, there is any, my lord, your lordship can pass the order. Otherwise, my lord.
Otherwise, my lord,
again-
if your lordships kindly give me one chance more, because since SDPO on the last occasion, my lord, last day,
Your case in with another chance.
because
If
my
you
lord,
give you a
they
chance, you could have improved your case.
SDPO, my lord, verbally, my lord, told me that your land is not required despite this report. My lord, may I go through the
That
report
is
and
also-
come back?
That has also been considered in the earlier report.
My lord, may I, my lord, go through the report and come back, my lord? Today, my lord, Mr. De, my lord, filed a report. May I go through the report and come back? If your lordships, my lord.
Very good. Let him go through the report. Report submitted on behalf of the state respondents is taken on record. Report. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear in the same heading on.
My lord, it's not matter, my lord, you have before the.
Yes, yes. That
Otherwise,
your
my lord,
lordship.
we-
Kindly, kindly.
it's some difficult.
14th December.
Yes, my lord.
14th December.
Grateful, deeply obliged.
36.
My lord, I was to submit because the
file has not come as yet. I'll just make it not to
Right. 36.
36, the file has not arrived as yet.
Yes.
From the, I'll just make it not to 37.
Yes. Well, this is my application. State is supposed to file the report in the form of affidavit as directed by your lordship on last two occasions. Mr. Day is appearing, suppose. Mr. Day has been engaged by your lordship.
My lord, is it is matter, my lord, you have copy.
Yes, yes, everything we have. সব কিছু করে দিয়েছি আমার ক্লার্ক ওই যে আমার ক্লার্ক করে
My
দিয়েছি
lord, as because my lord, your lordship was engaged in this matter, my lord. Perhaps
I have given the copy. My clerk has already given the copy. Number has been given to my.
That was the order was not there, my lord.
But what about case number is there? Case status is always available in the net. It is, this submission should not be entertained. Yes, absolutely.
You are habituated in the internet system. So I can't want to undo on that one.
তুমি habituated no.
No, my
তুমি তুমি স্মার্টফোন ব্যবহার করছো
lord.
এদিকে
আমার দরকার নেই স্মার্টফোন তো only
ফোন করার জন্য।
Please come back with the report on the next.
বললামই তো।
Then it
Yes,
comes
my
up
lord,
for the
I must-
state respondents.
একটু লিখে দেবো না।
The extension of
ওটা
time to submit the report in the.
একটা কপি আছে এখানে? কত তারিখে?
করে দেবো।
Paragraph, let the matter appear under the same heading on
আমি দিয়েছি
January.
আজকে দিয়ে দেবো ওটা দেওয়া আছে আমার হলো এটা
30/11/23 order.
38.
Sir, I beg to appear on behalf of the petitioner.
My lord,
Numerous
Mr.
occasion-
Amit is appearing for the state, my lord. My lord, may kindly grant a password, my lord. He got stuck in the rain, my lord.
But your lordship has heard below this matter on
My
numerous
lord, the
occasions.
state was supposed
Well,
to
under
serve
Act
an
2,
affidavit, my
Milord, under Act 2, the acquisition process was being initiated. But Milord, thereafter, Milord, I approached this honorable court on the earlier round of litigation. Milord, since I was not provided, Milord, any compensation, Milord, this honorable court directed my representation to be considered, Milord, upon giving hearing, Milord. That was done, Milord. Kindly takes up page 33 of my lord's brief, Milord. This is the reasoned order. Milord, page 34. From last paragraph onwards, your lordship will find, Milord, the observation.
The respondents.
Milord, on the last day also, Milord, again your lordship directed me to serve a notice to Mr. Ahmed. Milord, this is, Milord, the notice, Milord, that I have served, Milord, on 28th of November.
So let the matter be taken up for hearing today.
My lord, my kind.
Several dates have gone.
My lord, we are ready with the affidavits, my lord.
Okay.
You
Why are you finding it?
affidavit in the form of report in the form of affidavit by respondent number 3. My lord, may kindly takes the matter for hearing up at 12:30, my lord.
This court has several other matters
My
to
lord.
consider, sir. You are appearing for the state.
My lord, led by Mr. Ahmed, my lord.
My lord, I have noticed, Milord, at page 34 and 35, my lord would get, Milord,
that since the fund was not being placed by the requiring body, ultimately the requisition process which was initiated, that was not being made complete. So it's a lapse proceeding. I find, my lord, from the report as has been, my lord, filed today, though, my lord, there is, I do not believe, my lord, any direction was being passed, but still, my lord, what they are proposing that in the earlier, my lord, round of litigation and also, my lord, in similar kind of matter, this honorable court directed a direct purchase policy. Lord, my client is ready and agreeable, but kindly see, my lord, their reasoned order. Their reasoned order suggests that there is no procedure laid down.
Not today only. Tomorrow, no adjournment, no passover.
Then, my lord, kindly keeps it on Monday. Tomorrow I will not be there. Monday kindly.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph, on prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on Monday, 11th December.
Fine.
Please be ready, sir, otherwise it will be taken up for hearing,
Good.
even in your absence.
Great.
39.
Sir, I am for the petitioner.
I am for the response, private response.
Mr. Ravi for the respondent, state.
Private respondent.
Private respondent number 2.
Lordships, kindly come to page 26.
So the plenary objection I am making, my lord,
Landed advocate, my lordships, kindly see the date, page 30.
Yes.
on the mandatory report, the writ application is not maintainable.
But page 30, page 30, lordships.
It's under challenge, so they'll have the first right of audience.
My lord,
Maintainability of the writ petition is under
let
challenge.
them make submission about that.
Yes.
Your lordship will find the paragraph 7 is the sum and substance of the filing of this writ application. That the petitioner states that all of a sudden petitioner receives information from Bangla Bhumi that suddenly the classification of the efforts of land has been changed and not manipulated by the concerned authority by taking gratification from the private respondent, but by changing the classification of Pukut to house, and the area has then shown as 0.18 decimals. So this is the sum and substance, this is the change of record of rights. If it is, my lord, comes within the purview of section 4C and 4D of the West Bengal Land Reforms Act. If he has any grievance regarding the change of classification, my lord, the recourse has to be taken, my lord, challenging that record of rights on either under section 50 or 51A4, whatever may be my landed can be advised. Even assuming that not every pond has been converted into house, then how the bank of the pond is still existing till then? Matter, this is not supposed to be adjudicated by this honorable court or the jurisdiction vested. The classification has been changed, and it was converted into body. After that, I obtained the sanction plan. And if there is any wrong classification or change of record of rights on the basis of the application has been made, then that is a violation of 4C and 4D. Then it comes within the purview of the West Bengal Land Reforms Act. Because the paragraph 8, my lord, will find that the petitioner states the submits the private respondent number 12 with the aid and assistance of some official person change the record of rights of the aforesaid scheduled plot from Pukut to house without any conversion as per 4C or 4D. So this is the sum and substance. If this is the sum and substance, my lord, my submission before your lordship, this honorable High Court, my lord, under Article 226. My lord.
Let the petitioner reply.
Yes.
My lord, my reply is, lordships, what I have challenged, without conversation of land, filling up the pond, make a construction. My learned friend read paragraph number 8, but not full. Lordships, kindly see the paragraph number 8, what I have stated. Some of the official persons change the record of right of the aforesaid scheduled plot from Pukut to house without any conversion as per section 4C of the West Bengal Land Rules, so that none can agitate any point that she is making constructions by filling up the said pond. It is apparent from annexure P1 that the aforesaid scheduled plot of land is a pond for using the domestic purposes by the villagers of the said village. It is also apparent from annexure P5
So
that
your allegation is primarily under the Land Reforms Act.
no, my primary allegation is without proper conversation of land, they have filling up the pond and constructed the house.
Under what provision does this proper conversion come?
That is under 4C. That is correct. But lordships, kindly see what I have challenged. I have challenged
I have challenged before this honorable court that without any conversion,
The moment you challenge without any conversion, it goes out of this court.
no, without any proper conversion, filling up the pond and constructed the,
The court cannot decide whether it is converted properly or not. It is under the Land Reforms Act. You have to approach the appropriate authority. This is a specified act.
no, there, my lord, I may prayed there, my lord. I prayed there, my lord. Record of correction of record of rights, etc.
You can
But
challenge the conversion also there.
no, but filling of pond
You are
and
challenging the
constructing,
conversion.
filling of pond, how they, if they converse it, I have not challenged the conversions. If they converse it the same, I don't know they have converted or not.
You have said they have converted.
No, if they have converted the land, that is also not proper.
So that means you are challenging the conversion.
But lordships kindly see, filling up the pond is before this.
I can ask you to grant you liberty to approach the appropriate forum or have to dismiss it on this ground. It's not maintainable for this.
2 days time may be given, my lord.
No, not required.
No, 1 day time, because my lord, I have some instructions, they will go for appeal or not. Only 1 day time or
Not today.
no, my lord, no, Monday, my lord, lordships. Because it is Bharatpur, Murshidabad.
Phone.
No, if I not got that, my lord, that's why, my lord. Let it be on Monday, my lord, Monday.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 11th, Monday.
On
11th.
As you said,
Mal.
11th December.
40.
40, I beg to appeal on the petitioner.
Your Lordship, my senior, Mr. Satyajit Talukdar, is engaged in 550 court.
My lord, they have filed a report. Very peculiar case, my lord. No notification, nothing. Only forcefully they are showing that we have taken the position, but I am in possession. No compensation, nothing. My lord, no provisions under the 1894 Act has been complied, and from their own, my lord, report,
Affidavits have been called for this matter.
well, that has been filed.
So let it appear as a hearing matter.
But affidavit.
Mr. Dey, have you filed it?
No. We filed today.
Yes.
Inspection has come, my lord.
There is a direction for affidavits.
Direction to file affidavit in opposition. My lord, I have received all the things, my lord. So give me another chance, my lord. Last time.
So, Your Lordship, for the KMTA,
Find a
no,
affidavit
we filed.
They are filed, we have filed, my lord, the reply.
on record. The affidavits are not there on.
Ma'am,
Affidavit
Talukdar.
submit this.
Affidavit in opposition submitted on behalf of the
KMTA.
KMDA is taken on record. Paragraph learned counsel for the state respondents seeks extension of time to use the affidavit in opposition as called for. Paragraph let the matter appear, paragraph 2 weeks after the vacation.
Yes.
Oh, yes.
Paragraph affidavit in opposition be filed by the state respondents within 2 weeks after the ensuing vacation. Stop affidavit and reply, comma, if any, comma, be filed within a week thereafter. Paragraph, let the matter appear under the heading Group 1 hearing in the monthly list of January 2023. 24.
No, only indulgence will not make, no, only direct the peremptory will not, otherwise. Weeks after
And 3 weeks, so monthly list of February.
Only will direct.
Mention upon completion of affidavit.
Otherwise, our state again will come and again pray for time. My lord knows. My lord knows, my lord. Yeah, how many adjournment they may take. We are. I am grateful.
Monthly list of February. Yeah? It's 41.
In this matter, my lord, I am appealing for the petitioner.
My lord, I am for
Petition
respondents number 2 and 6.
I prayed for an adjournment on the ground to file an exception.
Yes.
I mean, can you do your lordship, though I prepared and it was, today I'll file one the copy, today I'll supply to my landed friend.
Today you have served.
Yes, my lord, let my landed friend take any another.
You have got 2 and 6.
2 and 6. Your Lordship.
They are the main answering
I am
respondent in this matter.
the Oil and Natural Gas Corporation.
Oil and natural gas. This was a forceful acquisition.
You need to go through this.
My lord,
You need to go through.
my lord, I would need to take instructions. I've just been given a copy.
The wrong I have been committed, my lord. I very beginning, my lord.
A chance to the respondents.
It's my fault.
No, my lord, in fact, if I don't go through this and I don't share it with the client, then my head will be guillotined.
I have committed the mistake, my lord. It's my duty.
Exception used by the petitioner to the report in the form of affidavit submitted on behalf of respondent numbers 2 and 6 is taken on record. Paragraph copy of the exception is made over to learned counsels for the respondents in court this day. Paragraph on prayer of respondent numbers 2 and 6, comma, the matter is adjourned. Paragraph, let the matter appear under the same heading on 17th January.
I cannot ask for both. Great, my lord.
Item 42.
Petitioners have not been appearing for a very long time. None appears for the petitioners. No accommodation is sought. Dismiss for default. Huh?
Well, 43, my lord, I am appearing with the petitioner.
The state.
At last occasions, my learned friend has filed an exceptional affidavit, and I will also, my lord, file a reply of the exceptions report. Now it has been, my lord,
I have filed report for that.
my lord,
Yes, what is the matter about?
my lord, matter is regarding the land acquisitions, my lord, acquired by the Special Land Acquisition Officer Mahura. My lord, ultimately, 1st October 2019, Annex C8, page 62. When I have already applied that how much land has been acquired, that certified copy to be supplied. In response to this, my lord, Annex P8 on 1st October 2019, the Special Land Acquisition Officer has been, my lord, intimated to me to the petitioner number 1 that with reference to the above, this is to state that you have applied for supplying the certified copy of land acquisition as well as the order of acquisitions in respect of LA case number 35 of 8990. In this regard, you are informed that the concerned case has been lapsed due to non-submission of fund.
Where are you reading?
By, my lord?
You are reading the report
Well,
of respondent number 6,
respondent number 6.
page.
My lord, page P8, annexure 62. Page 62. In the read petition. In the read
You
petition.
are saying report.
Well, coming to that after exceptional level.
Page?
And report. Page, my lord, 62, annexure P8.
Yes.
Well, when I was applied for certified copy. Now, in reply to this, with reference to the above, this is to state that you have applied for supplying the certified copy of land acquisition as well as the order of acquisition in respect of LA case number 35 oblique 8990. In this regard, you are informed that the concerned case has been lapsed due to non-submissions of fund by requiring body.
But
in time.
possession is with the authority.
Yes, Special Land Acquisition Officer is the acquiring authority.
They have taken possession.
They have taken possession. I mean, it has been utilized with regard to the canal, Kangsabati project and reservoir. Now, so no land has been acquired finally in this case, and no award is paid to any route concerned. There is no any award was passed, even no award was payment to the parties. Now, ultimately, my lord, writ petition was filed. Now, ultimately, my lord Justice, this matter has been assigned to my lord Justice Vivas Patanayak. Then his lordship was pleased to file a exceptional report from the respondent 6. That is the executive officer. Now, executive engineer has formed an affidavit that executive engineer has already been submitted a report that estimated land has been, well, the fund was created by the RB. That is, my lord, page. I am relied on this reply. $70,006, page 6, para 6. Page 4.
Para 6 of
Para 6 of my lord, exceptional report form an affidavit on behalf of the petitioner. To the report in form of affidavit filed on behalf of the respondent number 3. Respondent 3 has filed this report. My landed friend has also been filed a report.
your exception is yes.
My lord, that
Paragraph.
paragraph my lord 6.
They are served, they have not served the copy of the exception.
My lord, yes, my lord, I have to.
Two exceptions, one filed today, one filed on the earlier occasion.
Yes.
It's fine. Today they are what they are relying now, that has not been served. এটা আপনার রিপোর্ট আমাদের আমাদের রিপোর্ট তো 3
That affidavit one copy is with me.
Not
That was not served up.
handed over. Okay.
Here is that there is two reports. One of the respondent 3 and another report was filed with the
6.
respondent 6.
Yes.
Now here is the report has already been appeared that 70,000 something was 70,617.88 has been estimated by the respondent number 6 to make payment. But so far the fund has not been created by the executive engineer, that is respondent 6. It has not been passed any award or not to make payment. Only just report, and during the pendency of this case,
You are asking for compliance of the earlier order.
compliance of the earlier.
Where is the earlier order?
My lord, that is 16th October 2023.
Page.
Well, this is the order of this court.
This page. You have annexed it to the writ petition.
No. After that, my lord, this writ petition was order first. And my lord, regarding compliance in subject to the affidavit in compliance, as filed by the respondent 6. I have already claimed that they are saying that we are time has been lapsed, so no award was passed, or no award was make payment to the parties. That is in 2019.
So where is stated that this award was passed?
Well, it is appear from the exceptional report of filed by the respondent 6. Entire report has been submitted.
Filed by 6 today.
3 and 6 both.
6 paragraph.
From my report, page 5, it's my 6 report. Today I have filed.
Yes.
Page 5, my lord, it has been stated. Page 5, my lord. Roman 1, reference of records could be revealed to admit the receipt of the land by this department from the land acquisition department. This has been, my lord, approved by the recording body, my lord, executive engineer. 2, my lord, award amount was requisite by office of district magistrate and collector Bakura, white payment of such and such. The referred requisition for award money was complied with by payment with rupees such and such only by check number such and such the State Bank of India Bakura branch against LA case number, my lord, that is the one LA case by which the land is acquired, along with LA case all other case number such and such.
There is 35, LA case 35. Only other matter.
Yes, my lord, 35. LA case number 35, 89, 90. Yes, my lord.
34,
35 is also there.
35.
Yes, it is, however, disclaimed any information or response about the ultimate disbursement of the conversion. That has been done by the land acquisition department, whether that is disbursement or not. That is not.
No, it is not
report.
been disbursed.
So the amount has been disbursed by check number so and so in of State Bank of India.
By the requiring
Bakura
body.
branch.
By the requirement in favor of the land acquisition department. my requiring body has transferred the amount in favor of the land acquisition department. And land acquisition, whether it has been released in favor of the petitioner or not, that is not appearing from this report.
That should appear from the report of respondent number 3,
Yes, my lord.
because requiring body has deposited the amount.
Yes, my lord.
Requiring body has already been complied with by depositing.
But it is 27 lakhs and odd, not 70 lakhs. From where, how do you get
No, no.
70
This
lakhs?
amount is 70, not 70,000. 70,000.
Oh, it's not lakhs.
70,000.
Here they have deposited 27
There is the
lakhs.
total amount. Total amount.
What does the sixth respondent say? Have they
From
disbursed?
report filed by the one Soma Kumar Das.
Yes, Shomu Kumar Das.
Yes, my lord. By page 5, paragraph 10, my lord. In this regard, it is also to submit that after perusal of all available documents of LAKS, no document related to placement of fire shot for at that time has been found. Because our copy has been found.
So two contradictory reports.
Yes, my lord.
Contrary.
Need more instances, specific instances required, my lord. The report of respondent 6 has been affirmed just, my lord, the day before yesterday, my lord. But 17th of October.
It doesn't say anything.
Yes,
Yes.
18th October.
Respondent number 3 admits the acquisition.
Yes.
But regarding the compensation, nothing is said.
No, no.
Yes.
So let there be a direction for payment of compensation. Since the requiring body says they have deposited the amount.
Yes.
So only one more chance, my lord, because my there are two contradictory, my lord, the report, my lord. Let
Come
me,
back with further instructions.
yes, my lord, for the instruction. Only instruction I shall come.
Direction for payment of the amount.
Yes, if it is, my lord, forward before the land acquisition report, it should be, my lord, paid. My lord. Let me take one, my lord.
Acquiring body has deposited the fund.
Yes, yes.
It is
It's
lying
appeared.
with the acquiring body.
Acquiring
So
body.
they have to disburse.
They have to,
And that is the prayer of the petitioner.
that
That's
is
not the prayer.
along with the interest.
Definitely, because of the delay. A report in the form of affidavit submitted on behalf of the sixth respondent and exception used by the petitioner to the said report are taken on record. Paragraph. It appears from the report submitted on behalf of the sixth respondent that the
একটা দেখো তো রিপ্লাই একটা দিয়েছি কি আমরা
award amount with regard to LA case number 35/89-90 was deposited with the State Bank of India, Bakura branch.
It's not 3, it's not 6.
And duly communicated to the district magistrate and collector, Bakura. Stop.
আমাদের রিপ্লাই
Strangely, the report in the form of affidavit submitted on behalf of the third respondent indicates that no document relating to placement of fund as sought at the relevant time has been found. And also, there is no document relating to declaration of the award. Paragraph. Learned counsel for the state respondents seeks to take further instructions in this regard. Paragraph. Let the matter appear under the same heading on 21st December.
21st. Yes.
Short matter can be
Yes.
44.
My lord, in item number 44, Mr. Potakashi Roy is appearing for the petitioner, my lord. He is suffering from fever. So I'm asked by his clerk to pay for adjournment for today, my lord.
None appears for the petitioner several occasions.
My lord, I don't know, my lord. I am not in this matter. I was just.
I have to again record none appears for the petitioners because you're not appearing in this matter.
No, no. I am asked by Mr. Roy's clerk to pray for adjournment, my lord. I am not in this matter. Mr. Potakashi Roy is the petitioner.
And because my lord, each application is not maintainable. That is the recording
Land
is
Reforms
there.
Act. Land Reforms Act.
Yes, my lord.
Not today. Not today.
45.
Lordship, in item number 45, Mr. Rishabh Dattagupta is appearing. He's unwell and he has not come to court. I'm praying for not today, Your Lordship.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 25th January.
Your Lordship. Grateful.
Lord, item number 46, I am for the West Bengal Mineral Development Corporation, led by Mr. Shah.
Petitioner.
Lord, I appear on behalf of the petition, my lord. My lord, I am led by Mr. Shomo Mojumdar, my lord. Kindly passes over the matter, my lord.
Cannot be passed over.
My lord, in such circumstances, my lord, kindly grants not today, my lord.
After vacation.
Grateful, my lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 22nd January.
Grateful.
47.
Mr. Bandyopadhyay, report.
46 date কবে হলো? 22nd January.
Copy দিয়ে দিও। Thank you.
Yes, it's a short matter, payment of compensation.
Payment, at least the payment which is at
the court is
my
there,
lord.
yes.
At least the payment which is admitted by them, let that be disbursed subject to disposal of the execution proceedings.
Only one matter is pending for the executing court, my lord, not executing court, my lord.
So you'll wait till the matter is pending before the execution.
If any order is passed by lordship, my lord, then my lord,
There was a direction upon the executive court also by a coordinate bench that has not been complied with. Pay the compensation, there's a direction upon you.
because of one amount is lying with the, my lord, the authority.
That they have not filed a contempt application.
Well, which account that amount will be disbursed, that is not clarified by the authority. That is why that could not be, my lord.
Kindly see page 71, the report of the government leader before the court below. It shows, my lord, last but one page, my lord. From the top second paragraph, landed government leader. 71.
71.
One, my lord. May I? Landed government pleader appearing for the ADM-LA, Nodia submits that the order of this court has mistakenly moved to the office of the ADMG. However, they were aware of it and are taking necessary steps to comply the same. He submits further that the previously committed amount of rupees 1,81,000 approximately will be soon disbursed positively by the next date. However, the assessment of the decretal property was already done through the DSR and the requisite compensation payable was arrived at 35 lakhs. He submits that since the acquired land was already utilized by the Nodia Irrigation Division, the Irrigation Department will disburse the rest of the amount. He also undertakes to take up the matter through proper channel of the irrigation. The entire report shows the which department is supposed to disburse the compensation, my lord. And this order was recorded in July 2022. Initial acquisition in 50 years ago. Till this to this date, not a single penny paid. The execution case itself is attaining 20 years of phase it.
Yes, page 71, it's all very clear.
Yes, my lord, it's clear, my lord.
So after all this, a report was called for. You are again standing on the same.
Report
You cannot take the same stance now also, isn't it? How long will you take to disburse the compensation?
They have preferred the title suit before the planet court. That was decreed and judgment. The state preferred the appeal. That is, my lord, allowed on part. And the learned appellate court, my lord, the
Directed payment of compensation.
payment.
So where is that?
They have, my lord, filed a title execution case.
Yes, for
That is
compliance.
pending and it is of the order of the executing court. All the manner the petition is maintained. They have prepared an application manner under civil division under 227. That is also manner disposed of by the Sound.
That is praying for expeditious disposal of the execution proceedings.
But
Initially, my lord has required the report with regard to the amount which was to be disbursed as compensation. However, the report only.
Parallel proceeding. Matter is pending for decretal dues. This is compensation as directed by the appellate court. No, not at all. You have to pay this amount immediately. Let me dispose of the writ petition with a direction for payment so that you can come back in contempt.
Content, my lord. Extremely grateful, my
There
lord.
should be some executable order.
My lord, I'm grateful, my lord. At least the 35 lakhs which the government paid.
Listen to good words. It is used to harsh words.
At least I'll have something to hold on to if the directions, my lord. My lord, may I say submit two things? My lord, the government pleader by the order, my lord, the page 71 order, which I've just read it out, my lord, it shows that 35 lakhs was the admitted amount of compensation at that time. Let that be deposited with interest and that will be withdrawn by us. Other than that, the rest of the amount may be disbursed after the execution proceeding disposed of. The admitted amount may be disbursed to the petitioners.
The first amount is 1,81,000.
Now, which was to be given by the different department, and then rest of the amount was to be given by the irrigation department. My lord sees, he submits, my lord, he submits further that the previously committed amount, this was committed amount of 1,81,000 approximately will be soon disbursed positively by the next date. However, an assessment of the decretal property was already done through the DSR and the requisite compensation payable was arrived at 15 lakhs. He submits that since acquisition land was already utilized by the Nodia Irrigation Department, the Irrigation Department will disburse the rest of the amount.
So 1,81,000 will be disbursed by the state.
My lord.
Remaining amount by the
Irrigation Department. Let the direction upon both the parties, my lord. Both of them have been made parties. The respondent number 2 is the irrigation and the State.
Education, repeated school with a going amount of percent and now we mention for it. Those should be-
For reference, my lord, may I place another part of the order, my lord? My lord, kindly comes to page 61. This is another order recording the report by the ADMLA of the Nodia. My lord, third paragraph from the top. Since no proposal of acquisition has been sent to this end for acquisition of in respect of such and such land, the instant petitioner, but the same has been channelized through the above noted memo, an excess fund of rupees 32 lakhs is pending for placement from this end from the I&W Irrigation and Waterways Department for final payment. The amounts there for payment. This order was 2021, still today, not a single penny.
Kindly direct the authority concerned to release the admitted amount only, without mentioning that.
For admitted amounts
My lord.
recorded by, stated by the authority.
But 32 lakhs, which they are saying that is the total amount released
No, my lord.
by the authority.
35 lakhs,
35 lakhs, my lord.
page 71. 1.81 to be given by the state and the remaining by the recovering body,
Irrigation Department.
irrigation department. The facts of report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph heard learned counsels for the parties. Paragraph the facts of the case as recorded in the order passed on 22nd August 2023 is recorded here under. বলে এই the petitioners submit থেকে নেবেন এই অর্ডারটা এখানে আছে আগের অর্ডার the petitioners submit থেকে state respondents. Right. It appears from the copy of order sheet in title execution 6 of 6/04 dated 15
Arrived করেছে
July 2022
already done through DSI and the
that the
requisite compensation payable was allotted payable at 35. তারপর এখানে অর্ডারটা দেখো
that it was submitted before the execution court on behalf of the additional district magistrate within bracket land acquisition bracket close comma Nodia
রেস্ট অ্যামাউন্ট যে 35 লাখ তা তো নয়
that
রেস্ট অ্যামাউন্টে ক্যালকুলেট করতে বলেছে ম্যাটার এনহান্স
the previously committed amount of rupees 1,81,000 1,81,000
35 লাখ টাকা যে ও রিমেইনিং
approximately would be soon disbursed, comma positively by the next date. Stop. An assessment of the decretal property was already done through the DSR and the requisite compensation payable was arrived at about 35 lakhs. He further submitted that since the acquired land was already utilized by the Nodia Irrigation Department division, comma, the irrigation department would disburse the rest of the amount. Stop. He undertook to take up the matter through proper channel with the irrigation department. Paragraph is most unfortunate to note that the said amount has not been disbursed in favor of the petitioners till date. It is pertinent to mention here that an order passed on, this is page 61, the date is 24th or 4th,
61, my lord, date,
the date of the order?
my lord, I'm just
Last order, my lord, is the
24th of September 2021.
Passed on 24th September 2021 in the execution case indicates that the that an excess fund of rupees 32,3216427 3216427.00 was pending for placement before the state from the INW department for final payment. Paragraph, in view of the above, comma, this court is inclined to hold that since it is admitted by the respondents that rupees 1,81,000 is due to the petitioners from the in view of the above, this court is inclined to hold that since out of the requisite compensation amount of rupees 35 lakhs, comma, rupees 1,81,000 is due to the petitioners from the ADMLA
ADML.
from the fourth respondent and the remaining amount from the seventh respondent, comma, the writ petition be disposed of, directing the fourth respondent and the seventh respondent respectively to disburse the said amounts in favor of the
Petitioners and the performer respondents.
petitioners এর আগে যেখানে due to the petitioners বললাম না ওখানে petitioners and the performer respondents এর আগের লাইনে since an amount of যেখানে বললাম due to the দেখুন petitioners বলেছে ওখানে and the performer respondents add করুন and the performer respondents add করুন ওখানে disburse the petitioners and the performer respondents within 4 weeks.
I'm grateful, my lord. I'm extremely grateful.
Communication of this order. Hearing is not further. Hearing is not necessary.
All on record, my lord. Admitted position, my lord. The entire 35 lakhs, my lord. The 1,81,000 from the state and the 32, my lord. I'm grateful, my lord.
Disposed of which attribute?
I'm grateful, man.
48.
May I seek?
48.
I'm for the petitioner, my lord.
State.
Yeah, yes. I know.
Exception.
I rely upon the notice. I rely upon the report.
Mr. Bandyopadhyay, report.
Yes, it is there, my lord.
Mr. Bandyopadhyay is not in a working mood.
Report is with me. Huh?
No, one report is by the NHA, I think.
No, it is by the
No, my lord,
Yes.
from the state, my lord.
State.
I have not any direction, my lord, to file any report.
No. It is the state who filed the report. I have received the copy.
Nothing.
There's some limit. Some limit. হ্যাঁ আমি কপি দিয়ে দিতে পারি
Other way around.
only one thing I want to submit to your lordship. আমি একটু বলে দেবো, তারপরে যদি মনে হয় তুমি ইয়ে করে দিতে পারো। Initially, well, this is related to acquisition under the National Highway Act. Initially, the plot of the land of the petitioner was assessed as a Bagat. Classification is Bagat. So it is recorded as VT. I came before this honorable court. This honorable court was pleased to hold. No, the assessment should be made in terms of the VT. That your lordship will find it is there challenging the page 23.
Is an retribution order.
Yes, I have challenged that computation that you should have assessed my land as a VT, because my record of right stands in that as a VT you cannot change your classification of your own and reduce by compensation. And your lordship will find the relevant portion, page 24, third paragraph, on the face of the record. My lord, got it?
Page 24.
Page 24. It is a continuation, my lord.
Yes.
So the other portion has been stated. I am not relying upon the some allegations against the authorities. On the face of the record, which represents cannot dispute the land in question is Bari or VT, and therefore the retribution is entitled to compensation as the enhanced for the category of land as appears from the award number 3 dated such and such, passed by the arbiter, which is a part of the compilation produced by Mr. Day for the state of West Bengal, which is 2 is kept on record. The respondent concerned shall make payment of the enhanced compensation to the petitioner within a period of 1 month for the date of communication of these orders. This is the sum and substance. Now, challenging this order, the state preferred an appeal. Your lordship, may I turn to page 29.
Yes.
There, my lord, the portion which there's some allegation or allegation has been made against the authority, that has been strike out. But the ordering portion regarding the payment of the compensation in terms by holding the same as a VT class of land, that has been upheld. Now, pursuant to which, my lord, I made a representation to the authority concerned that I am entitled to get payment as per the enunciation in terms of the order passed. But according to the calculation now, the report is not before my lord. I have a copy of the report. If your lordship kindly takes up the report.
They have given a calculation in the report.
Yes, that's the only thing I want to submit your lordship on their calculation. I'm not on any other thing. If your lordship, can I turn to this one? This is the
PG5 order.
CG5. Yes, after that one, this paper is with my lord. It is there, my lord, but I cannot mention the page number.
I'll just find it.
May I find it out for your lordship and hand it over to your lordship? The last.
Calculation sheet
Yes,
for
yes.
compensation.
Yes, land acquisition department decision on the
Yes.
calculation for compensation.
Yes.
This was the first time it came to know from this report only. Can you consider date of the award at the left hand side top?
Yes.
31st March 2015. I got it.
Name of the awardee, date of the award, yes.
31st March 2015. Date of gazette notification such and such. Date of position such and such. Probable date of the arbitral award is 13/34/2019. I'm accepting. So the award was declared after 31st March 2015. Now I can turn to column that 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th column from the left. Solatium before arbitration and solatium after arbitration.
Yes.
So therefore, my lord, after 2015, whether I am entitled to 30% solatium or 100% solatium. It is their report, my lord. I am handing over a copy to them. There is no indication in the either in the award.
You're challenging the arbitral award.
No.
My lord, this is the
the-
component, my lord. This solution is a
Is a
part of the
component.
award.
Part of the award.
This solution is a part of the award, my lord.
That, my lord,
Argument said, my lord, if the amount has been enhanced, my lord, that means his amount has been enhanced.
yes. That is award is the amount.
Award has not been challenged.
This has been decided by the arbitrator.
No. That is the arbitral award I have annexed. Your lordship, fine. There is a copy of the arbitral award.
একবারে করে তারপরে দিই। Mr. Roy, the report needs to be on record
As your lordship.
because you are relying, your submission is entirely on the report.
Yes, that's it. I'm relying upon the report. এই নাও, দাদা। দান, তুমি ওটা নাও, আমার কাছে একটা কপি আছে, কিন্তু জজ সাহেবকে তো তোমার একটা এফিডেভিট দিয়ে দিতে হবে।
একটা রিপ্লাইটা একটা না দিন, নাহলে
তোমাকে তো জজ সাহেবকে তো একটা অরিজিনালটা দিতে হবে।
Please prepare a fresh report with an affidavit. Before vacation.
আড়ানো কি করি পার্থকে দিলাম
আমাকে দিতে তো
হ্যাঁ তোমাকে দিয়েছি 10,000 টাকা ফাইন দেওয়া হয়
কি করছেন
সমিতদা ইয়ে হয়ে গেছে।
Copies are handed over in advance, then the.
Yes, that is why it has been handed, but I have relied upon that report. এফিডেভিট দিয়ে করা আছে, কিন্তু তুমি তো এটা দিয়ে তো এমনিতে জমা দিতে পারবে না। Yes, that's
ঠিক আছে আমি এটা করে নিচ্ছি
তোমাকে ইয়েটা দিয়ে দিলাম।
করে দিচ্ছি
Learned counsel for the, ওটা ফেরত দিয়ে দিন।
কত
Learned counsel for the state respondents seeks liberty to reaffirm the report in the form of affidavit since the original has been misplaced by him. Paragraph, such liberty is granted. Paragraph, let the matter appear under the same heading on 11 January.
As you wish. Or 17th January, my lord, I fixed another matter on 17th. 17th, my lord, 17th.
$49.
I am for the petition. Only 1 minute time will you get.
To file report. Come back. Please do not deprive them.
No, only 1 minute, but they will file report only.
I have to file reports in matter.
No, you have to file report, that has to be considered.
But I am to file exception.
79
madam.
mentioned
I am to-
matters.
Yes, only madam, this is, I am to file exception.
49.
479.
479.
49 Act order.
49.
49 Act order.
In this matter, my lord,
The form of
479.
affidavit submitted on behalf of the state respondents taken on record. Paragraph, learned counsel for the petitioner seeks to use an exception to the said report. 49 report দিচ্ছি madam. You will use an exception.
Yes.
To the said report. Paragraph, let the matter appear under the same heading on 19th January.
My lord, I am handing up the report.
But
Please file the report.
I've already filed one.
but
479.
479.
অসুবিধা আসছে না
matter, my lord, I am appealing for the petitioner, my lord.
আসছেন না তো
File it.
Yes, 479.
My lord, this is my application, my lord. 479.
তুলসীদা
State.
Now the petition, my lord, Mr.
Only
Taluk
KMD
is
is
appearing for the
appearing.
KMDA, my lord.
Yes.
Mr. Taluk is appearing for the KMDA, my lord.
Yes, please.
In this matter, my lord,
Yes.
the petitioner was allotted, my lord, a plot of land, my lord, belongs to the KMD authority, my lord. That, my lord, lease deed was executed by the authority, my lord. Thereafter, possession was handed over to the petitioner in the year of 1987. What happened, my lord, in the meantime, my lord, for a prolonged period of time, my lord, even the land was recorded in the KMC authority, my lord, with the KMC authority, all the tax and bills, my lord, was deposited, my lord. All on a sudden, my lord, in the year of 2021, my lord, the land was reallocated to the other person without giving any opportunity of hearing to the petitioner and all this, my lord. This is my main allegation. What has been,
Was terminated?
lordship?
The lease was terminated?
No, that still subsists, my lord. Without giving any opportunity, that particular land has been reallocated to the other person. That is the main allegation, my lord. I was not given any opportunity of hearing, no notice was given for termination to the petitioner and all this, my lord.
Yes, Mr. Talukar.
Would you kindly allow me 2 days time to come with instruction?
With the report?
With the report or instruction as your lordship. I may come back
I think
in the
it
next
will be
week also.
necessary because you have to annex documents. Whether opportunity of hearing
Ye-
was granted.
Yes, certainly, my lord, what the petitioner is alleging, that cannot be without cancelling.
So please come back with a report.
Yes.
Let him come back.
Lordship.
Learned counsel for the petitioner.
And one submission, my lord. The maintainability of the writ petition, my lord, may kindly be kept open.
Why on the
Because,
ground?
because after a long time, whether the lease was granted in favor of this petitioner on certain terms and conditions.
An order of 2022 has been challenged.
Order of 2022.
2022.
But the lease deed in question, which my learned friend that was executed in 1987.
I'm keeping it
When
open, but
yes,
because he says that he has not been given an opportunity.
yes, let it be kept open.
The lease deed was executed, my lord, in favor of me, my lord.
Learned
Without giving any
counsel for the
opportunity.
petitioner submits that during subsistence of a deed of lease executed in his favor, in her favor, in respect of the property in question by the KMDA, the authority allotted the same property to another person without affording an opportunity of hearing to her. You have not impleaded the other person in the writ petition?
My lord, that liberty may be granted, my lord.
Yes.
I want to impede that particular person, my lord.
Because he
Only, my lord,
Balancing against
only, my lord, my learned friend may be directed to.
Name.
His name is there, my lord, but I don't know the address, my lord. My learned friend's record is there, my lord. He may supply with me, my lord, that.
Why should I? You collect and
My learned friend has supplied, my lord.
no, certainly not.
Court cannot direct. Otherwise, petition becomes, it will not be maintainable otherwise.
If you
Because
can
he
make
is a-
allegation, you can also collect it.
Party. Yes.
I may be given liberty, my lord, to amend the cost title and amend that impede that particular person, my lord.
Paragraph on prayer of the on prayer of the petitioner, liberty is granted to amend the cause title of the writ petition by incorporating the name of the person in favor of whom the second lease has been granted by the KMDA. তারপরে the না না এটার পরে করো এরপরে করো কারণ এটা করতে হবে না এরপরে পরে A learned counsel for the KMDA seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 19th January.
19th.
Next.
My lord is kept
Oh,
open.
indeed.
The maintainability point may keep.
Oh, the issue of maintainability is kept open, actually. The issue of maintainability is kept open.
But I placed in a short nutshell the fact of the case. Yes, yes.
My lord, today, my lord, at 10 p.m., lord, 10 a.m., lord, you have received the copy, my lord. My lord,
But
You need some time?
I am seeking similar order, my lord.
Case example to following. Allowed he challenged the notice dated 1st June 2020.
It is at page 16, my lord.
my lord, there is no.
My lord,
date
there is
mark.
a provision of the notice that you can file an application, new presentation before the authority. That
But
was not-
similar order has been passed in identical 3 matters which were before your lordship but taken away from the list of my lord and placed before my lord Justice Bimar Patnaik. That was decided and the similar order I'm seeking here also your lordship kindly sees there is no difficulty in passing such an order. Nobody will be prejudiced.
Yes, I have.
My lord,
Nobody will be prejudiced.
I was, my lord,
না এই ম্যাটারটা ছিল
Let me see the order.
এই matter-টা দেখো।
And
এই matter টা
similar
যেটা-
order was passed in 3 other
My lord,
matters.
my lord, kindly fix the matter.
Let me just go through the order.
But it will be difficult for me, my lord. There is no difficulty. No.
Copy, my lord, how my learned friend?
She had been in other 3 matters.
So how do I?
Same order is required. The fact of the case are more or less same. Only the petitioner is only different, my lord.
আর করোনি কেন আগে?
আরে করার হয়েছে চাইনা ডিপার্টমেন্ট থেকে দেয় না আমি কি বলবো
দেখাও।
Yes, you were granted to make the representation.
Yes.
Since the date is over. Let that order be passed.
Yes.
In this writ petition, my lord, there is no representations, my lord.
No. Please come to page 16.
Lordship, that is
Your
the notice.
Chapter 26(2).
Yes, my lord.
The notice says that he can file representation within
Yes.
3
Yes,
days.
my lord, Lordship, this notice has been issued in the year 2022.
That's
Now, he
why
approved this matter, Lordship, in the year 2023.
he wants to file this representation.
My lord, kindly give me one day time, my lord. One day accommodation, my lord.
Not to
Tomorrow.
My lord, Monday, my lord. Kindly, my lord, fix a Monday, my lord.
Monday.
My lord, one day accommodation, Lordship, take some time, Lordship, to take the instructions. My lord, Monday, my lord.
I don't think you need further instructions.
My lord,
Only
tomorrow
the
night,
time
I have
frame
some
has to be
quantum
within it.
matters are there, my lord. So, kindly fix on Monday, my lord.
On prayer of the National Highways Authority of India, the matter is adjourned. Paragraph, let the matter appear under the same heading on 13th December.
My lord, kindly recorded, my lord. I have received a copy today, my lord. On this ground, my lord, I am only seeking the instructions.
How can that be written
My lord,
in the
this is my affidavit of service, my lord. Your lordship kindly take. The affidavit of service filing today may be kept.
Affidavit of service করুন তারপর একটা লাইন লিখুন learned counsel for the National Highways Authority of India submits that she needs to take instructions in this matter since she has received copy of the brief this morning.
My lord, yes, my lord.
My lord, let the matter retain its position, my lord.
Same 13th December বলুন
481.
Admit. Hey, come on now.
Yes, for it.
Your lordship, this is my application, your lordship.
Yes.
Yes, your lordship, this is challenging. Yes, your lordship, this is my affidavit of service, my lord. My lord, the petitioners herein are challenging. I think Mr. Day is appearing on behalf of the state.
And the panchayat?
My lord, the petitioners herein are.
You serve the panchayat?
Yes, my lord, everybody has been served, my lord.
Yes.
Yes, your lordship, this application pertains to challenging an order of eviction passed by the collector and the SDO, Kontai, Purvo Mednipur, your lordship. In 2006, your lordship, the Kontai Gram Panchayat set up.
Appealable?
Yes, your lordship.
Isn't the order appealable?
My lord, this order is it's applicable to the EA, but in the similar.
62 order?
Yes, your lordship, this similar matter, similar series of matter in where your lordship has passed an interim order restraining the opposite party to take possession. May I hand over the copy?
Have you filed an appeal?
Yes, we have filed the appeal. It's still pending, your lordship, but in the similar matter, I'm placing the order, my lord.
Later on, what is your case here?
My case is here, my lord. I was not given a chance to substantiate my case. The respondent number 4 has alleged that I'm an illegal occupier in respect of the 2 stalls. But my lord, I have been in possession by paying proper taxes, and there are rent receipts.
Does it make your occupation legal, sir? You're aware.
But my lord, this setup, the stalls, the knowledge was
the order.
at page 34. 34 is the notice, and page 35 is the order, my lord.
Yes. And you have preferred an appeal against this order?
Yes, my lord. We have already preferred an appeal. At page 37, it's there.
47 is the appeal. Yes, so what is your prayer here?
My lord, I am seeking an interim order restraining the opposite parties to kindly not vacate me till the disposal of the appeal, my lord. Since in similar set of matters, your lordship has passed an interim order restraining the opposite parties to not take possession till, I think, from January 2024, my lord.
What does this order indicate?
হ্যান্ড ওভার করেছে।
What does this mean? Can anything be made out from this order?
Yes, my lord, I'm placing another order, my lord.
Not necessary. Mr. De, let the appeal be disposed of within 1 month. Till disposal, no coercive action. Affidavit of service. Paragraph none appears for the eighth respondent despite service. It is contended on behalf of the petitioners that the petitioners have preferred an appeal before the commissioner within brackets Medinipur division, comma, Paschim Medinipur against the order passed by the subdivisional officer, comma, Contai on 10th April 2023.
না কারেকশন করে দিত, কারেকশন করে দিত। এটা পূর্ব অর্ডারটা 34 আচ্ছা কন্টাক্ট পূর্ব মেদিনীপুর অফিস থেকে আসছে। পূর্ব মেদিনীপুর
comma, directing the petitioners to vacate the property in question within 3 weeks from the date of the order and restore the property
না আমাকে যদি ইনস্ট্রাকশন
in its original
অ্যাপিল
state.
হয়নি।
Stop. The appeal is pending. Stop. The petitioners seek a direction upon the SDO.
No, my lord. That is
It is
the
DM.
Direction upon whom? Not to evict?
Not to
Till disposal of the
disposal SDO.
Order will be state, SDO order state.
SDO.
Order of the SDOs will be state.
SDO. My lord, one indulgence, my lord. It's not Paschim Medinipur, my lord. It's Purbo Medinipur, my lord.
Purbo bolo, Paschim bolo, Purbo. Purbo. Thank you. Purbo Medinipur. Then the petitioners even seek. Petitioners seek. Now, the petitioners seek stay of the order dated 10th April 2023 till disposal of the appeal. Paragraph. Upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that since appeal preferred by the petitioners is pending before the
Respondent number 2.
second respondent, comma, the second respondent be directed to consider and dispose of the appeal within 1 month from the date of communication of this order in accordance with law. Paragraph. The order passed by the subdivisional officer, comma, Contai, comma, being the sixth respondent herein on 10th April 2023 be stayed till disposal of the appeal. Which are disposed of.
Maybe disposal.
482.
Wait, please. On the last occasion, it was mistakenly submitted by us that they are private respondent, but it is not so, my lord. The matter pertains to, my lord, refusal of permission.
You are the petitioner.
My lord. My lord,
So where is it hearing?
Yes.
What about the private respondents?
my lord, there are no private respondents, my lord. It was
There are no
mistakenly submitted by us, my lord.
Jila Parishad is there. Have you served the Jila Parishad? Jila Parishad
Yes,
is there,
yes, yes, yes.
municipality is there. Where is the service?
It's already submitted.
The affidavit of service. আছে তো সার্ভিস হয়েছে তো?
No track report.
Track report then?
Servant company. Since service upon all the respondents is not complete,
Huh?
comma, let the matter stand over till 18 January.
18 January. Under the same heading, well?
No, not same heading.
But there's some urgency, my lord, because
483.
the petitioner is 90 years old, my lord.
Some urgency, but you have not served.
My lord, I'll take a chance. Wait.
483.
My lord, I beg to appear for the petitioner. My lord, before your lordship takes up, my lord, I need to, my lord, tender my apologies. Probably it's not one of the best drafted petitions, but there are certain, my lord, averments which ought to have been taken is not there. This is my admission at the very outset. Now, my lord, my grievance is that the PHE department, Public Health Engineering department, is encroaching upon my land in the garb of doing, my lord, some water pipe and drainage, my lord, work. Now, my lord, I have made a representation, and my lord, as of now, my lord, I would only, my lord, I won't go beyond that. I would only, my lord, beseech your lordship, my lord, let there be a direction upon them to consider my representation. Nothing beyond that.
Well, my written instruction is that, Lord, in the same dag number, there are vested land also, which are used by the PHE, but they are not using the petitioner's Khotiyan. But demarcation is necessary.
And that, yes, that is demarcation is required.
Consider the representation, do the needful.
Well,
Where is your representation?
My lord, it's a demand for justice, my lord. I think I will have to place a demand for, yes, my lord, that's why at the outset I, my lord, mentioned. Because, my lord, it is admitted position. The harsh land, they say that they are using the harsh land, but my grievance is that in the garb of that, you are using my land also. If there is a clear demarcation, then, my lord, the issue can be settled. The demand for justice. Demand for good advocacy.
Affidavit of service. The petitioners allege that the respondents have encroached upon a portion of the petitioner's land and utilized the same without acquiring the same by due process of law. Not been acquired, it has been utilized.
Yes, ma'am.
That is your case. The petitioners seek to submit a comprehensive representation ventilating their grievance before the concerned authority and pray for a direction upon the authority to consider the representation at the earliest. Paragraph is submitted on behalf of the respondents that the who should consider
not the ADM, LM, not ADM, ADM.
is necessary.
No, only because the written instruction is that we have not used, that is why. Just let it be kept on record. Lord. Since they have given a written instruction.
My lord, there is a dispute between the harsh land and the, my lord, private land. Sir.
Let them decide.
Yes, ma'am.
The fourth respondent.
Fourth respondent, let him decide.
The fourth respondent be directed to consider the representation in accordance with law. The statement of fact submitted on behalf of the state respondents is taken on record. The paragraph in view of the above, the petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the fourth respondent within 2 weeks.
Madam.
Within 2 weeks from date. Stop. The fourth respondent is directed to consider and dispose of the representation within 4 weeks.
6 weeks, Lord.
Within 6 weeks from the date of communication, from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Disposed of which.
My lord, will they offer us and, my lord, afford this personal hearing, my lord?
Yes, I've stated that.
Because, my lord, documents needs to be, my lord, produced before the authorities.
After line, the petitioners shall be at liberty to produce relevant documents before the authority at the time of hearing.
Extremely grateful, my lord.
Communication that is in fact included in the hearing. When a hearing is called,
My lord, sometimes,
always at liberty.
yes, my lord, but sometimes
the
they,
court will
yes,
not allow.
yes, my lord. Mr. Banerjee must be knowing well, my lord.
Anyway,
Much obliged.
next. 484.
No, this is my petition. This is affidavit of service. I am filing. The statement.
This is in respect of inaction in grant of freehold title deed of a refugee plot under the Refugee Rehabilitation Department. That allotment was made in the year 1958 in the name of the grandfather of the petitioner.
1958.
58.
Yes.
Like not in no freehold title deed has been issued as yet. But that is my grievance. I mean, in the meantime, on latest in the year 2021, inspection was held. But in inspection, the petitioner's name was there, but the measurement which has been taken, that is not. But without measuring, it has been detected, mentioned. So that is to be corrected upon fresh measurement. Let kindly have a look to page 20. This is the allotment letter.
I think the state has to come back with instructions.
What happened after allotment? They have not annexed any documents that they, after allotment, whether they have taken a step or they have approached with the authority for allotment of gift.
Have you filed any representation before the authority?
Yes, my lord.
Where is it?
Representation now, my lord, they have filed, my lord, that
After the inspection and representation,
For
page
inspection.
41. Page 38.
for physical inquiry.
It was for correction of the inquiry report. Like, what I am praying, my lord, direct them to consider, direct the director to consider my case, and this writ petition may be treated as representation.
File a comprehensive representation for the authority,
My lord.
annexing all the relevant documents.
Yes, yes.
Let the authority consider within a
Yes, my lord.
stipulated time frame.
My lord, I shall file. Yes, definitely. And that will be done upon given opportunity of hearing
Yes,
to
yes,
the.
absolutely. Affidavit of service. It is contended on behalf of the petitioners that the plot in question was allotted
Page 21, the letter of allotment. Page 20, sorry, madam. And it's at P1, page 20.
in favor of
The grandfather of the
predecessor in
petitioner.
interest / grandfather
subdivision
on or about June 23, 1958. And said predecessor was in possession of the property all throughout.
That inquiry reporting page 36. Annex of P10.
The petitioners have been possessing the plot after demise of their grandfather
And their father.
and their grandfathers. Is it?
Different fathers.
After demise of their predecessors in interest. The grandfather after demise of their predecessors in interest.
Yes, you could. Yes, you.
The petitioners complain that deed of gift has not been executed and registered in their favor. Executed and registered in favor of the original allottee or the petitioners till date. The petitioners seek to submit a comprehensive representation in this regard before the concerned authority and pray for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the respondents submits that who should consider?
This one is a 3 month.
The deputy director.
Deputy. Yes.
The third respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the petition is disposed.
মানে ডাইরেক্টর, ইট মে বি ডাইরেক্টর।
Director করবে না।
Director done many cases.
যেটা যা করবে না দাদা আমি আরে প্রতিদিন মামলাগুলো আমরাই তো করি, ডিপার্টমেন্টের ইনস্ট্রাকশন যায় তাই বলে দিলাম।
As your lordship,
With
please.
liberty to the petitioners
এই
to
authority করে।
submit a comprehensive
মানে আমি এসডিও থেকে
the
ব্যারাকপুর
third
এসডিও থেকে
respondent
পাঠিয়ে।
within 2 weeks.
Yes. করে আসবে স্যার কোর্ট অর্ডার দিতে।
Within representation within 2 weeks.
Within 2 weeks from date. Stop. The third respondent is directed to consider and dispose of the representation within 4 weeks.
Some more time is required.
6 weeks. Within 6 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law. Paragraph. In the event the representation is decided in favor of the petitioners, comma, deed of gift be executed and registered in favor of the petitioners within a month thereafter. They'll decide within 6 weeks, and if it is in your favor, within another month, they'll execute the deed.
My lord, get put to your lordship.
Disposed of?
এবারে হয়তো within 1 month. Date of
নামটা বলে দিস। Get.
Next.
এটা কম।
485.
করে দিন আপনারা। আচ্ছা চল দিন।
Lordship, I would like to take you, Lordship, the last page,
Service.
which order
before
is,
that.
yes, ma'am. Page number
The total file
111.
anyone for the respondents.
It has been served.
It's the DVC and the state.
Yes. The DVC. My allegations against DVC.
Give me a minute.
Yes.
Who appears for the DVC generally? All are not served. Item dispatched.
Only at that time it has been dispatched, some of them
So
returned,
where is the further track report?
and some of them returned back.
Where is the service on DVC? I do not find the joint director. It's the ADM, DM, Deputy General Manager.
May I once?
Yes.
Try, let me see.
There is no Deputy General Manager. You've served someone. Please find out.
Yes, ma'am.
এটা দিন তো না।
দেখো
Sorry.
চেক করো আস্তে আস্তে যাই বলো
The DVC is not reflected in the postal
Yes,
receipts
ma'am.
at all.
65 Millard Diamond Damodar Valley Corporation, and Millard is it has been delivered. Yes, Millard, I delivered. Page number 9. Along with Millard. Page number 6, the second one. Page number 6, the second one, and page number 9.
State is not appearing. Mr. Day, may I request you? Please serve a copy to me.
Yes, Millard, we will.
Yes, now you can
Yes.
proceed, please.
Now, page number 111 is the impugned order I am challenging. Lord, what happens? The petitioners impugned order, page number 111. The DVC has passed an order subject to a contempt petition filed before this court. Lord, the history is, Lord, the petitioners are holder of plot of lands, 119 petitioners, cultivated lands. The DVC set up a thermal project
And the ashes of that, my lord, distracted the lands of the petitioners. Now, they filed a representation, not considered, filed writ petition, my lord, is considered to pay compensation. Now, compensation paid till 2015, the present case, my lord. Now, they made also writ petition that compensation was not paid. There was a direction for giving hearing given, my lord, order not passed. We filed a contempt application before your lordship. In between, my lord, they pass an order. I am challenging that order, which is page 111. Now, my lord, our contention is that you have paid till 2015. The page number 14 reflects the, my lord, payment history since 2011-12. DVC is the answering. I have not made a state party. My lord.
This matter will be heard by
The mentioning was upon notice, I'm sure.
Yes, my lord.
with notice.
Yes, please.
Yesterday-
Yeah, I've served before this.
Yesterday you give notice to DVC.
Long time back, I served
No,
notice.
that
No, my
can't
lord.
be, my
My lord, I mentioned on the Friday.
Yes, sir.
Lordship was pleased to say that let mention on the monthly because monthly was coming out. Mention on Tuesday. And that's
Did you
why
mention upon notice?
upon notice.
To the
Upon
DVC?
note. Yes, my lord.
Will you do, because they are the answering respondents.
Yes, my
In
lord.
their absence, I
Let,
don't think it
let
will
them
help.
file a reply also, my lord.
No.
Let they can hear the matter. I'm not seeking anything. My lord, let them hear. They can go through. I will give a copy to them. Let them go through that. My lord, they can make a reply. My submission is only. Now, kindly see page 111. The last para. Now, they gave a hearing. That is not the disputed fact. The compensation has been paid to the stakeholders for the affected land, barring land, already acquired such and such. Now, my contention is without any evidence, without any documents, just one line order they have passed. We have not received the payments till date. Let them pass and produce any documents that they have paid.
So, will you serve the DVC?
Yes, my
or
lord, we will
just
serve.
Intimate them the adjourned date, that's all.
I will,
Because
my
you
lord.
have already served.
Yes,
So
my lord.
please serve a notice upon them.
I will, my lord.
Affidavit of service. And none appears for the respondents despite service. Stated, Mr. Their appointment regularize করুন. Please serve a copy to Mr. Dev because
Yes,
I'm
my lord.
appointing him in this one.
I'll make a photocopy and send it.
Copy service direction. Paragraph, let the matter appear under the heading motion on 22nd January. Paragraph, the petitioners are directed to serve notice upon the
Now, page number is 27.
first, second, and respondent numbers 1 to 4.
1 to 4.
Notice upon respondent numbers 1 to 4, intimating the adjourned date. Please intimate the
Yes, my
adjourned
lord.
date.
Everything. Grateful, my lord.
সেটা হচ্ছে তোমার 22 জানুয়ারি।
Next. 486.
My lord, I am for the petition.
I am for the state.
And what happens, my lord? I have been granted a long-term mining lease. But due to the order of the Honorable Supreme Court, I had to file environment clearance certificate. My lord, come to page 14 first. The ADM, on the basis of the judgment of the Supreme Court, my lease area has been suspended until and unless I produce page 14, my lord. Page 14.
Page 14 are several names.
No, my lord. The order, and my lord, come to page 15.
14, 15 are names.
15, no, my lord. Niche na. My lord, I'm sorry, my lord, then. No, that. My lord, come.
15 is the order of stopping the extraction of sand. Page 15.
I'm sorry, my lord.
সুশান্ত দা এইটা 15 কথা আমাদের।
Order dated 24th August 2016.
হ্যাঁ এটা কত পেজ আছে?
হ্যাঁ 10 কপি আছে না?
15 is not, my lord. 15 is the order of the
Order dated 24th August 2016.
My
No,
lord,
no,
it's an order dated 6/5/2021 for granting permission for mining lease granted under rules.
And my lord,
Granting
page
permission for
16, my lord.
Yes, my lord, that is in our
My
Page
lord,
15,
what
that is
happens, my
the
lord?
annexure, maybe the pagination is wrong.
Wrong. Yeah, definitely.
It's annexure P2.
P2 is the granting permission for mining lease, and annexure P3 is the letter to the senior geologist from additional district magistrate.
Yes.
Yes, my lord. P2 is that, my lord, the ADM requested the senior geologist to send the mining plan. And my lord,
Lastly, a representation.
P3 is the letter which by the ADM directed to the senior geologist to send the mining plan immediately, my lord. Even now, it has not been sent. I made a representation before the ADM that kindly consider my mining plan immediately. Kindly consider my representation dated 24th May 23 and accept
Page
P7.
19. Page 19.
This is
Page
18
19.
here.
But pagination is wrong. Absolutely.
Is in our page 19.
Page 19. Page 19. Kindly consider my representation.
For approval of mining plan,
Yes, my lord.
let it be considered.
My lord, the steps has been taken by additional district magistrate. That letter has been communicated to the senior geologist. That is pending, my lord. Accordingly, let the presentation be considered.
By the senior geologist.
The senior ADM to consider.
No. My lord, I am reading, my lord. Letter dated 16th February 2022.
Yes.
Written to the, my lord, addressed to the senior geologist, director of minor minerals.
Yes.
On the last two paragraphs I am reading. Hence, as the LTML of sand was granted as per permission of the West Bengal Minor Minerals Rules 2002, no letter of intent of award of contract was issued in favor of Sadoy Brahmachari, but a provisional grant order was issued as stated above. Therefore, the mine plan and progressive mine closure plan of Sadoy Brahmachari over plot number such and such, with an area such and such, is recent herewith.
Sent herewith.
To take necessary action as per
that is also
pending. That is pending. That a decision to be taken by the senior geologist.
Hello, senior geologist is not made the party here.
Let it make a party to the senior geologist.
Senior geologist need not be made a party. The additional district magistrate is the authority. And
ADM is the authority, madam. ADM is the authority.
The plan.
No, this is an interdepartmental communication. This is not for the petitioner. I don't know how the petitioner has got this. But this is in the between the departmental.
So let the additional district magistrate consider the representation. Accordingly.
The counsels for the party.
ভালো করেছিস
The
এটা শেখাচ্ছিস
petitioner
পুরো
seeks consideration of
আমি তো
his
শিখবে
representation submitted on 24th May 2023 before the 2023 before the concerned authority.
না পরে তো বললে হবে না
Requesting approval of his mining plan. Paragraph, learned counsel for the respondents submit that the additional district magistrate shall deal with it.
Is my lordship. Additional district magistrate.
Additional district respondent 5.
Respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the 5th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 4 weeks. Within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of which
Faithfully,
Before rising, my lord, may I pass? To mention, my lord, that item number 79, my lord, today morning I have mentioned, my lord, very urgent matter, my lord. All the fees, my lord, start, my lord. Can you see the photograph?
You are mentioning upon notice.
How upon notice, my lord?
Didi eta niye নিন তো উনি সকালে বলেছিলেন
my lord, item number 32, my lord, due to rain.
I have not called. I'm sorry.
My lord, kindly, my lord, make it just not
Original side mentioning. Roman, call the raised list, please. Court applications under Article 226, item number 1.
Matter, my lord, petitioner is very much health condition of the advocate of the petitioner is very not well, my lord. At least, my lord, 2 weeks time, my lord.
So that takes us to the vacation. Come back after vacation.
After vacation.
On prayer of the petitioners, comma, the matter is adjourned, paragraph, let the matter appear under the same heading.
Yes.
11 January.
January.
11th January.
11 January.
Item number 2.
I'm the applicant too. The applicant.
The petition is at my instance, my lord.
Yes.
My lord, an application has been filed by Mr. Ghosh's client seeking impleadment, which I oppose. Impleadment.
This is my application for it is a party because my lord, I consider, my lord, I have some interest in the case. If your lordship looks at
Opposition to this.
I don't think it's purely a question of law, my lord.
My lord, the prayer, my lord, which has been made in the writ petition, your lordship looks at the prayer.
What is your application?
To appoint an arbitrator in terms of section 11 of the West Bengal Premises Requisition and Control. And
When did you file your application?
my lord, I filed to
G এটা কোথায়? একটু
K1.
My lord, in this matter, my lord, I am appearing on behalf of the
দাঁড়াও,
state respondent.
আগে দেখো কি বলছি।
Yes. You are appearing for the state.
Yes, my lord, I am.
কেন কোনটু তো হ্যাঁ কোনটা বের করছো তো
This.
You lordship got it, my lord? My lord got it.
Give me a minute.
You lordship look at the prayer in my petition I have quoted here in my application. He has made a prayer for appointment of an arbitrator in terms of section 11 of the West Bengal Premises Requisition and Control, Temporary Provisions Act 1947 to determine the amount of compensation to be awarded to the petitioner for the period commencing from midnight of 31st March 1992 till January 13, 2022, say the date when the requisition property was physically and actually delivered to the petitioners within the such time-bound period as to this honorable court may seem fit and proper in the facts of the case. But the facts remains, my lord, that although the petition has been served, the facts I know, my lord, that the 2-3 my lord, places, the 2 guarding places in a building, some of the portions were requisition at the instance of the corporation. Corporation, my lord, the election office was there. The government election office, my lord, municipal affairs. And that, my lord, ultimately several proceedings were conducted regarding acquisition to be made or not. Finally, there is an order in a writ petition presented by my learned friend, my lord. There, my lord, Mr. Harish Chandra, my lord, passed an order directing the corporation either to acquire or to release the property. Acquisition, my lord, cancel. Then, my lord, ultimately the acquisition did not take effect. And the requisition the court directed regarding the payment of the compensation during the period of occupation until the property is handed over. That process was completed, conducted, and since the immediate payment was not made, a contempt proceeding was there. Then in that contempt proceedings, ultimately the first land acquisition collector computed the compensation, and as directed by the court, my lord, that was, my lord, paid by us. Now, my lord, he is asking for in that, my lord, issue. The issue is that, my lord, in my expression, the issue has been set at rest. Now, he is asking that because of one sentence of my lord, Mr. Harish Chandra in the judgment, that he has not decided or issue whether the compensation amount is, my lord, the proper or not. My lord. Obviously, the court is not going to, my lord, adjudicate, or court is not, my lord, calculate the amount. that the ultimate the direction was upon the first land acquisition collector, and my lord, he on hearing the parties, my lord, and my lord, the assessment, the mode of assessment, which is, my lord, provided under the act, my lord, in terms thereof, he calculated the amount. And my lord, I have paid the amount. Now, my lord, again, that after conclusion of that, and after taking that money, now he is asking, he's presented the writ application for appointment of arbitrator to determine the amount of compensation for the same period. The period for which one of the rent compensation has been paid by us. In terms of the direction of my lord Mr. Tandon and the computation made in terms thereof by the first land acquisition collector. Therefore, my respectful submission, my lord, if the arbitrator is to be appointed, as my land has prayed for, then I am the party, I am not a necessary party in my respectful submission, because ultimately whatever the order will be passed or whatever the computation directions will be passed, my lord, ultimately affect me.
You will have an opportunity before the arbitrator.
But I may have the scope to say that this cannot be maintained, this petition. Because if he gets an order, my lord, without my lord impeding me or without my giving me an audience in the proceeding, then my lord, it could have been said the High Court has passed an order permitting the appointment of the arbitrator for adjudication afresh. Therefore, whether afresh, my lord, it could be done or not, whether their section, particular section which has been mentioned, that would, my lord, be lie or not applicable in this particular case, that is to be addressed by us. Therefore, my lord, in terms of the High Court's order, you also say that you could be given an opportunity of hearing before the arbitrator. But if there may not be any necessary occasion to go to the arbitrator by my client, and I will be submitting, my lord, the petition cannot be maintained for appointment of the arbitrator after so many things had been over. Therefore, my interest is definitely there. I am submitting to your lordship, my lord, that I must be present in the proceeding when your lordship will pass an order. If your lordship passes an order, your lordship may be pleased to pass an order after hearing me. Your lordship knows, my lord, when a party should be appointed, either the necessary party or proper party. If your lordship do not consider me as a necessary party, but I must say, I am a proper party, because my interest is there. It's a requisition with a compensation, my lord, to be paid ultimately by us.
I don't think your presence is necessary in the present writ petition. The arbitrator can be given an
But I shall object to appointment of the arbitrator and applicability of that particular provision. It's not a simple thing, my lord, that he is coming, my lord, the first round of litigation, and this is, my lord, fixation of the amount.
You have not annexed any document in support of your contention?
My lord?
What are the documents that you have annexed?
He has annexed the document. He has not supplied me a copy of the writ petition because
You still do not have any local.
no, that's right. That I'm not saying so. But I say, my lord,
You want to be impleaded as a party.
well, I say
Annex all the relevant documents.
relevant documents. They have annexed to his.
Interested
But
party.
he is. I am showing to lordship, my lord, that he has annexed the document. The order of my lord, Mr. Horish Tandon of the order, and there your lordship can see, my lord, the directions of the court, my lord, regarding appointment of regarding the first land acquisition collector for appointment. Whether after the first land acquisition collector decided the issue, whether the arbiter could be appointed or not. Well, I have a point by to argue before lordship's court. Because that was the direction for fixation of the rent. He could have said before before my lord Mr. Tandon, not the land acquisition collector, but the arbiter to be appointed. And there is no scope because the determination had already been made much earlier. And this is an enhancement.
You should have annexed these documents to your application.
Well, my lord,
You have to refer to those documents when you are making your submission.
well, I'm submitting that property which is requisition.
Everything in the air.
Well, not in the year, because in his petition he has annexed. I'm submitting on the basis of the judgment he has recorded. There on entire facts have been stated. in the judge.
Blanket submission, sir. You have to refer to the judgment.
Then, then your Honor, can I give me an opportunity? Then I'll file supplementary.
Let us hear the petition. Yes.
But then if you also will give an opportunity on the regarding the judgment and other things, my lord, I can. But so far other points which just now I'm indicating, that I can argue provided I implemented the party and give a copy, whether it could be maintained or not, whether there is scope for application of section 11 of the act itself. After so many things is over.
Let us hear the petition.
Now this matter, my lord, has a checkered history, my lord. But admittedly, my lord, my learned friend will not join issues, my lord. 3 portions of premises number 2 Gaston Place were requisitioned under the Temporary Act. My lord, the Temporary Act was ceased to have its force in 1989, my lord. The state, my lord, issued a notification under Section 4, which was followed by a declaration under Section 6. Good, bad, indifferent, my lord, the acquisition proceedings lapsed. No award was passed within the time contemplated under Section 12. So, my lord, we took out a writ petition before this court, saying that now since the acquisition has lapsed, the state or the beneficiary of the requisition could not be permitted to stay in that property for eternity, number 1. And number 2, from 1989, that the date from which the Requisition Act spent its force, therefrom till today, they were supposed to pay us compensation for their unlawful occupation. Kindly takes up Justice Tandon's order in this regard at page 23.
Admitted. Even admitted.
It's an admitted position, my lord, that the state requisitioned and the beneficiary was the KMC. No qualms on this, my lord. Kindly takes up page 30, the relevant portion, my lord. I will not trouble your lordship much.
30.
Page 30, my lord. My lord sees this.
It says that it is lapsed.
It's lapsed. No, thereafter, let's say, it is not in dispute that the steps were taken for acquisition such and such, not to reach finality, because the collector did not publish the award as such would stand lapsed. Even this court finds the acquisition proceeding no longer surviving, being lapsed under Section 11. So, my lord, acquisition lapsed. Thereafter, my lord, kindly takes up page 33.
Yes.
It is thus manifestly clear that after the lapse of acquisition proceeding, as award is not made within the time stipulated therein, the property cannot remain in acquisition eternally, since extended period under proviso to such and such, the possession of corporation is palpably wrongful, illegal, and therefore required to be given back to the petitioners. So thereafter, my lord, next page, page 34. My lord, sees it is brought to the notice of this court that an arbitrator was appointed by the court for ascertainment of the compensation required to be paid to the petitioners for requisition of the premises, and the said compensation was determined as far back as in 1989, and since thereafter no revision has been made as yet. My attention is drawn to Section 11 of the Temporary Act, which provides the mechanism and or mode of determining the compensation by agreement, and in the event such agreement is not reached, the state government is empowered to appoint the district judge or the additional district judge and an arbitrator. So this was the finding. So they did not pay. No assessment was done. We initiated a contempt. The contempt was disposed of, because during the period of contempt, when it was proceeding, the state handed us over the possession. And, the land acquisition collectorate, in terms of the order of Justice Tandon, was pleased to assess a particular amount, which they have paid. Now, we are aggrieved by it. So, we have a right under Section 11 to pray for an arbitrator. Now, kindly sees page 69. The paragraph, which the last paragraph, since the compliance, just 4 lines above that, whether the quantum of compensation is fair or justified cannot be gone into in exercise of contempt jurisdiction. The moment the court finds that the order has been complied with, it is open to the petitioners to take appropriate steps as permissible in law. So, now when kindly takes up the Temporary Act.
Yes, it's this.
Section, so, Section 11, kindly takes up,
Yes.
11B, I'll be referring to. No agreement can be reached. The state government shall appoint a district judge or an additional district judge as arbitrator. So, I fall squarely within 11B. So, I make an application to them, to state, to appoint the arbitrator. They don't.
I come up in rate. Now the corporation, being a beneficiary, wants to impede itself. Now, whether that is permissible is the question before my lord today. My lord kindly takes up the judgment of this Honorable Supreme Court. My lord, report in 2010-14 SCC 285. The relevant paragraphs would be paragraphs 13 to 16, my lord. Millet sees paragraph 13. At the commencement of the proceedings before the arbitrator, the state government and the person entitled to receive compensation are required to state their respective opinions as to the fair amount of compensation. Section 11(1)(d). Thereafter, the arbitrator has to determine the amount of compensation keeping in view the matters enumerated in clauses A, B, and C of Section 12. Once the award is made and signed, the arbitrator has to inform the parties to the reference by sending a notice in writing and also send copies of the award to the collector and the person or the person interested. Thereafter, what is most significant is to note is neither at the stage of fixing the amount of compensation by agreement, nor at the time of appointment of arbitrator, the state government is required to consult any person, including the beneficiary of the requisition. The only person with whom the state government is required to negotiate the amount of compensation is the one whose premises are requisitioned. An application of a reference of the case to the arbitrator can be only made by a person who was a party to the unsuccessful exercise undertaking for fixing the amount of compensation by agreement. If the state government nominates a person having expert knowledge as to the nature of the requisition premises to assist the arbitrator, a corresponding right is available to the person whose premises are requisitioned such and such. In terms of Section 11(1)(d), only the state government and the person to be compensated have a right to state their respective opinions as to the fair amount of compensation. The person to whom the requisition premises are transferred has no role in any of these matters. The use of the expression, the person to be compensated in clauses C and D of Section 11(1) clinches the issue. A person like the appellant does not fall in the category of person to be compensated. As a sequel to the above, this is where I lay emphasis on, it must be held that a person for whose benefit the premises was requisitioned or to whom the requisition premises are transferred does not have any locus to participate in the process of determination of compensation by agreement or in the matter of appointment of an arbitrator or reference of case to the arbitrator or nomination of a assessor. So, the beneficiary has no business in the matter, whether at the time of appointment and even when the arbitrator is adjudicating the issue. And I don't know why Mr. Ghosh is so crying hoarse about it. In the initial round, an arbitrator had been appointed. Kindly sees that order for appointment of arbitrator is annexed to my writ petition at page 73. Because prior to 1989, I was entitled to compensation. So this court appointed an arbitrator. Kindly sees page 73.
Yes.
So sees Lalita Almal, my predecessor versus State of West Bengal. The KMC was not a party. Kindly sees application by consent of parties disposed of appointing London district judge of not 24 Parganas having seat Barasat. Let him mention reference. So KMC was not even heard. Now, thereafter, the arbitrator passed an award. That is at page 74. Now, against this award, Mr. Ghosh's client, represented by Mr. Ghosh, came up before this honorable court. Let's seize this judgment, where this honorable court, taking aid of this very judgment of the Supreme Court, held that the appeal at their instance was not maintainable. Kindly seize, Sir, যেহেতু আপনারা appeal করেছিলেন, So, is the res judicata of the highest degree, Issue clinched, advocates clinched. Seize, What happened was, when the appeal was filed, initially we did not take up this point, Thereafter, we preferred an application, saying that the appeal was not maintainable. Despite that, this honorable court, has held that the appeal was not maintainable at their instance, the last page, last 5 paragraphs. Page number 8, we have considered the rival submissions. So placing reliance on this judgment of the Supreme Court, this honorable court has held that the KMC had no right to prefer an appeal in so far as it did not have a locus to participate or challenge the decision of the arbitrator. So in such view of the matter, the presence of the KMC, at least in the writ petition, is not warranted. These are the submissions.
My lord, I could have asked for it, pray for a time to go through the judgment, but even then, I just simply submitting to your lordship. Lordship has seen that arbitrator was once appointed by the order of the court. Therefore, my lord, whether the appeal was taken out, whether my right is there at the time of appointment, that chapter closed. Section 11 applied. I understand. 2002, when the order was passed, my land friend just pointed out.
Yes.
Requisition was made by a long back. The arbitrator was appointed for determination of the compensation. How many occasions, how many times the arbitrator could be appointed? It's a case of enhancement of the compensation.
Confine your submission only to your impediment. Not
That is why I'm submitting, because that is the I'm submitting. I am a necessary party because Section 11 does not apply here. That would be my submission. That is my locus standi is because he is a major player which cannot, which affect my interest. Today it is appointed, then it could be said that the appointment has been made because you have no locus. Because I can object to the appointment of the arbitrator. I have a locus because I have an objection to the appointment of the arbitrator. It's not. It's
no right to participate in the arbitration.
But I have, my lord,
Object to the appointment.
my lord.
The Honorable Supreme Court has very clear terms stated that you have no right to. You are the beneficiary.
But I am a beneficiary, but I am submitting. I have paid the amount for the entire period for which my lord, my land friend has claimed, my lord, over and again. Over and again, appointment of the arbitrator.
Liberty to come up with a separate writ petition. Not in this one.
But a separate writ petition, how can I? Because there is no cause of action. Cause of action would come, my lord, even if a lordship passes an order. But the thing is this, I am objecting for appointment of the arbitrator. It's a case of enhancement of the rent compensation, not the appointment of the arbitrator for determination of the rent compensation. But that would be my precise submission, but that writ petition is not maintainable. That is the reason I want to be added as a party. Your lordship, after hearing me, if your lordship sees, my lord, that I have no locus and my lord, the determination of the appointment to be made, your lordship do it. But I want to be full-fledged hearing, my lord, because the law, my lord, stands in my favor. I am submitting to your lordship, my lord. The law, my lord, which has been my line is pointing out, that is with reference to Section 11. I am talking about Section 11, 14 is applicable, and that application has been made by the my lord, Mr. Horish Tandon. But the appointment of the arbitrator the chapter is closed. Appointment has been made, my lord, by the LA collector for enhancement of the rent compensation. That has been done by the earlier order. That is the reason I am objecting to.
I would like a little bit of a clarification from the petitioner. An earlier arbitration was filed, amount was enhanced. So
May I say this?
need a further arbitration.
Kindly take page 96 for once.
Yes, 96.
So, requisition comes in 65, 75,000 such. Till 1989, this arbitration, the early arbitrations.
For the remaining part.
Yes, it's as simple as this.
When was possession given to you?
2023.
The document?
I'll show Malot, kindly sees. I'll just show Malot. I believe my learned friend will not object on that, Malot. I'll just Malot. Malot, would see Malot page 71 in my demand for justice, Malot. In my demand for justice, page 71, second paragraph, 5th line, 13 January. I believe my learned friends will not join issues on this score. So, what I am claiming is 1989 to 2023, this illegal occupation, the compensation which they have assessed. My lord, I don't agree. So there's disagreement, my lord. 11(1)(b) applies. It's as simple as that, my lord.
And for the remaining part, you are
Yes,
explaining.
yes. Even the contempt court could have passed itself since
Logically, section C, section 14, and C, my lord. Once it is determined in respect of the execution premises, then the question of enhancement comes up.
Determined till a particular period.
No, particular period, not for particular period. Determination, my lord, the rate. Rate is the issue.
No. The period is there. The judgment of Justice Tandon says till delivery of possession. Possession was delivered in 2023. The assessment is till 1989. So what about the remaining
Well,
period?
then there was no occasion. There,
Is it compliance with the court's order?
no, there is no occasion then. There was no occasion then to appoint the landlord, my lord, the land acquisition collector for determination of the compensation. Arbitration is different. Your lordship says arbitration is disabled.
Play when they are not happy with the compensation decided.
My lord.
Arbitration comes into play when they are not happy with the agreement. They do not agree to the compensation decided by the land acquisition collector.
Well, because I am agree because my lord, compensation had already been assessed and paid, and my lord, it is a case because he could have said before my lord, Mr.
One single document that from 1989 till delivery of possession, compensation has been assessed and paid.
The court directed for assessment. My lord, Mr.
One
Tandon.
document,
My lord.
a single document to show that you have paid the amount. Till 2023, till delivery.
My lord,
2023, he hasn't paid.
No, sir. They have paid an amount, my lord. That portion I admit.
And you are not happy with that.
Yes.
Then if it is not happy, I'm submitting. That is the reason I'm submitting. This is a question of appointment of the arbitrator. It may be question of the enhancement, and that enhancement section 14 is applicable, and for 14 could be applicable, and that has been done by the Justice Harish Tandon. Therefore, I am objecting to this. Section 14 speaks about the enhancement. And they calculated for enhancement of the rate, and for that period.
Enhancement was made till 1989, sir. Please.
Well, enhancement, I'm submitting to your lordship, enhancement, the rate has been enhanced, which was the rate was prevailing by the arbitrator. Arbitrator fixed a rate. I accept for a particular period.
You're a necessary party in the writ petition.
Well, if it is not necessary, but but if I'm not a necessary, but I'm a proper party.
I don't think so.
But I rely on a judgment, you logically see.
It's the matter after vacation, my lord.
You are not ready.
I'm not ready for the first fight KMC between that is why, my lord.
My lord, may I say this, my lord? I don't stand in there. I should not be standing in. But the point is, today, the KMC is not a party.
KMC is not a
Not a
party.
party. So it goes out, my lord. As regards, my lord, Mr. Devroy's submission, my lord, there's an order passed by this court and the law is absolutely clear. So if you can come back some, because we have been waiting for quite some time.
Even with regard to this application, I think Mr. Devroy is asking for some time. He has to take instructions.
With regard to the
Come back on
KMC, my lord.
first Thursday after vacation.
My lord, with regard to this application for intervention, my lord. My lord, KMC, my lord.
I deal both on the same day because it's a very short matter. I can deal with both. Yes, both will be dealt with on the same day.
And then kindly keeps it part heard, my lord.
Not necessary. Immediately on reopening, I said.
Well, so far as necessary for proper party, I will rely on a judgment next day on the submit.
Can rely. Can rely.
Rely on the judgment so that learned counsel
Yes.
go through it.
But it's an AIA 1963 Supreme Court 786.
Please give the judgment.
Copy list আছে আমাদের কাছে রেডি আছে
You logically see, my lord, paragraph 10.
Paragraph?
Paragraph 10.
কত 52 সুপ্রিম কোর্ট স্যার একটু বলুন না স্যার
1963 Supreme Court. AIA 1963. 63 তো বললাম তো।
কত গো
1963 সুপ্রিম কোর্ট
আপনাই কি স্যার পড়াবে নাকি আমাকে স্যার পেজ নাম্বারটা বলুন
600 কত
Principle.
That is, I am submitting, my lord. It is a settled principle, my lord. When a writ petition comes up, by landowner contention that he is not.
Have to substantiate that you are a proper party, which you have not been able to do this far. I'll give you an opportunity further on the next occasion.
My lord, very good. Very good.
If you can, then it's the court's discretion. Very clear. And this is settled now.
কাগজটা দিন তো ওটা
Learned counsels
জেরক্স করতে
for
হবে
the-
জাজমেন্ট
Heard learned counsels for the parties. Learned counsel shall photo have. Paragraph, learned counsel for the state respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 4th January, the first Thursday. 4th January.
4th or 11th, no?
4th will not be there. He'll not come back after his vacation.
I have nothing to say, Manoj.
Yes, Mr. Debra, 4th will not be there.
11th.
Very well, 11th.
I do not know.
11th January.
Great.
No, sure. থাকবে আমি।
মানে জাজমেন্ট মানে আই মেক ইট জেরক্স এন্ড হ্যান্ড ওভার টু লসেস কোর্ট
Recorded, আমার লেখা আছে ওখানে। I have
আচ্ছা
written in the judgment.
ঠিক আছে আমি একটু রেফারেন্সটা একটু লিখে নিই
Reference to দিয়ে দিলাম।
রেফারেন্সটা লিখে নিই
Yes, yes.
এক সেকেন্ড
I'm so grateful, Manoj.
I repeat, I'll give you both the issues on the next week.
Item number 3.
ঠিক আছে
The report?
786
Yes. This is unfortunate. On the earlier date also you sought extension of time. Then
ও দুটো অর্ডার দিল না অর্ডার দিল না একটা জাজমেন্ট দিল জাজমেন্ট আরেকটা
I have a
নিয়েগুলো
copy has not yet with
no,
me.
I'm not accepting the report. It's not on affidavit.
Let it be on the next Thursday because we will get. But I will get only 2 Thursdays because 14th and I think 20.
This Thursday. Yes.
14th is Thursday.
Can you come back on 14th next Thursday? Next Thursday. With a report.
No.
Learned counsel for the state respondents. Learned counsel for the state respondents seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 14th December 2023. 14th December, please be ready with your report. December, you're taking several extensions. And it appears to be a short matter. Offer letter has been issued, permit has not been issued.
And the vehicle.
That explanation is necessary.
You know?
রাখো